Yeah.
Great idea.
Yes. Yeah.
The time is 1:05 PM, Thursday, August 27th. This is the regular board meeting for the CLTC.
Half a day, good afternoon. Welcome to the CHamoru Land Trust Commission regular board meeting for today, August 27, 2026. Here at the CLTC Conference Room, Suite 223 in the ITC building utility. Members of the public who wish to comment may do so by emailing cltc.admin@cltc.guam.gov. To view this meeting virtually, you can log on to GovGuam Live YouTube channel or join via Google Meet. The official meeting link is posted on the CLTC website. We will now take call for the attendance. Commissioners, please say present when your name is called. Chairman, Mr. Earl Burrito.
Present.
Commissioner Fabrina Spicio.
Present.
Commissioner Jeremy Rojas.
Present.
Commissioner Annie Makepeace joining Google via Meet. Commissioner Makepeace.
Can we see who's online?
She's online.
Oh, but how come we can't see her?
So I got a message from Carlos Camacho, he cannot log on.
You're not on.
No, I mean, you're not, you're, we can't.
We're gonna allow people to come in to the meeting.
Look at all the people.
So you pin this one. You should pin the commissioner. So unpin this and then pin commissioner. Is this the one that everybody is on?
I think,
We have to discuss that because there's a
Can you hear us?
if they're doing technical difficulties, don't we take a break? Don't we get offline? Don't we take a break until we get back online? Because this,
So we'll pin her because she's the commissioner.
okay, I'm just wondering because there, do we have?
There we go.
There's Carlos. There's Hernandez.
We can fix that.
Wait, okay. Do you want to do a mic test?
Commissioner,
Is it the
Mr.
same
Carlos, or Mr. Camacho, can you hear us? Oh, wait, you're muted.
Is Mike's muted?
At the bottom. The mic at the bottom on the left. There.
Mr. Camacho, can you hear us?
Can you hear me? I
We
can,
can hear you.
the, I could hear you talk to me, so that means I could, I guess.
Okay.
Commissioner Makepeace, can you hear us?
I'm gonna put back on mute, and so I'm ready to talk.
Thank you.
So Commissioner Makepeace is online. Can you hear us, Ms. Commissioner? Would you like me to proceed?
Let me try and see if I can get over her.
Chairman, would you like me to proceed with the, or do you want me to wait for her response?
We have a quorum already, we have enough for a quorum, so go ahead and proceed.
All right. Chairman, we do have a report. We would also like to recognize CLTC Management, Acting Administrative Director, Ms. Angela Camacho.
Present.
Thank you. In compliance with Open Law 5 GCA Chapter 8, public notice of this meeting and its agenda was published in the Pacific Daily News on August 20th and August 25th, 2026. Notices were also posted on Guam Public Notice Portal and the CHamoru Land Trust Commission website. Before we begin, a quick reminder regarding our house rules. Public speakers are limited to a maximum of 3 minutes each. For our virtual viewers, closed captioning is available on our YouTube channel. Thank you.
I now call this meeting to order. Application.
Publication.
Okay. So false order publication, it was. I just said that.
Can you just go ahead and announce it again, just
Okay.
go ahead and announce the,
Yes, so our publication was posted on Pacific Daily News, August 20 and August 25th, 2026. Guam Public Notice website as well, and as well as CLTC's website. And then please rise for the intercession. Refreshing, que was tabular in Minnesota. It was tabular because that was people and national who operated my system, Jackie, Sandy, Kenny, Ikatura, Milwaukee, Harry, Hamilton, Tana, tomorrow. We instructed the lecture down to Joe's Tata. Estina Pittman, Helia Pippia, Sandy Bendia, Deep and Dad and Waha.
Remain standing, please. We're going to have the invocation. Itatamami ni gagaw gilangit at juda este na komisyon para shogu para este na init ng CHamoru Land Trust. Na klaro para hitat palisiri para iminalenta. At juda ang Kristusayna para iminari itatawahan. Mga manayan tuloy maganiti dan itatawahan niya. Si Diyos protehem, si Diyos bendicihem, viva sana, viva CLTC, viva Guahan, sana maasik. Thank you. Before sitting down, I would like to give 1 moment of silence. We just recently lost one of the agency employees through medical reasons. It was a very tragic death because it occurred outside in the parking lot. Okay, thank you. Another short prayer. Almighty Father in heaven, I humbly ask that the Holy Spirit guide our decisions in the service to Guam and the CHamoru Land Trust. Our commitment to protecting and defending the culture and the benefits to Guam is unwavering. In my remarks, I'm going to touch on unlawful lease or license. Unlawful lease or license of CHamoru Land Trust properties. A license was issued without proper authority and the operation has been ongoing for over 10 years plus. No payments have been received during this occupation. Checklist for remediation, legal arguments for remedies when an unlawful lease or license has been issued on CHamoru Land Trust properties with no payments received. Document and access the situation. Gather all paperwork related to the license or lease, which is agreement, communication, and payment records. Verify whether the lease or license was issued with proper authority according to CHamoru Land Trust regulation statute. Legal review. Identify relevant laws, regulations violated. Seek a legal opinion noting lack of authority for the issuance, non-payment for use, and provide notice to occupant and send a formal letter notifying the occupant the license is void due to lack of authority, and set deadlines for compliance. Attempt negotiations or remediations. Offer the possibility of settlement, payments of arrears, and for a compliant new lease if settlement fails. Prepare legal documents to file for eviction and or removal for summary proceedings. Recovery for unpaid rents, injunctive relief to stop ongoing unauthorized operations, possible restoration of property, file a civil suit in the appropriate court citing violation of CHamoru Land Trust Act or relevant legislation, unlawful occupation, non-payment. Attach all documents showing lack of authority and unpaid amounts. Seek recovery and restoration. Ask for damages which are back rent. Obtain order for eviction. Demand restoration of the property. Consider referral for investigation if evidence of wrongdoing by public official. Refer for administrative or criminal investigation. On the legal arguments, the license was issued outside the legal authority and is void from the beginning, breach of statute. Occupant is in violation of CHamoru Land Trust regulations and statute. Occupants receive unjust enrichment. The occupant benefited without payment, so restitution is compulsory. The land trust properties must be managed for beneficiaries. Unlawful occupation harms the trust. Restitution and back rent. CLT must demand payments for use for over the 10-year period. The trust can remove any occupant lacking valid authorization. Step summary. Investigate and confirm unauthorized license, gather all documents and evidence, issue formal notices and demand compliance, negotiate or mediate if possible, prepare for legal filings for eviction, and refer for administrative criminal investigation if warranted. Void lease and license. If it can be established that the license was issued without legal authority, then it is void from the onset. Breach of statute. The occupant is in violation of CHamoru Land Trust regulations and statutes resulting in unlawful occupancy. Unjust enrichment. The occupant has benefited from the use of land without making payments, which necessitates restitution. Public trust doctrine. The management of the land trust properties must serve the best interests of the beneficiaries, and unlawful occupation undermines this trust. This approach not only ensures adherence to the law, but also seeks to protect the integrity of CHamoru Land Trust properties effectively. This structured approach aims to address unlawful occupancy while protecting the integrity of the CHamoru Land Trust property. On my next segment of my remarks, it's addressed to the Guam Raceway Park. As we engage in ongoing discussion regarding the Guam Raceway Park, we find ourselves at a critical juncture characterized by a take it or leave it ultimatum. Our intent is to forge a partnership with the newly established Guam Motorsport Association. However, it is imperative that we respect our obligations concerning commercial leases. The Chamorro Land Trust Commission, COTC, operates under a mandate that requires any lease agreement for the property to reflect no less than 10% of its appraised value, a stipulation grounded in law. At this moment, it appears as though our negotiations have reached an impasse. Primary focus of the COTCs is to advocate for the interests and the benefits of the local community. Despite the current stalemate, COTC is signaling a willingness to soften its stance to facilitate future collaboration with the Guam Motorsport Association. Our goal is to achieve a win-win scenario that aligns with our mandate and supports the aspiration of the racing community. It is critical to acknowledge that the racing community in Guam constitutes a small fraction of the overall population, and the issues surrounding the raceway have persisted for approximately 3 years. In my assessment, for the Guam Motorsport Association to achieve compliance, it must revisit its feasibility parameters and align them with the stipulations set forth by the COTC. It is now time to reach an agreement based on the prevailing terms or to consider moving on. The next steps must reflect a commitment to collaboration, mutual benefit, and adherence to legal requirements. Thank you. Next on the agenda is the approval of minutes. Approval of minutes for July 16, 2026.
I make a motion to approve the minutes from July 16, 2026.
I'll second.
A motion has been made to approve the minutes and second. We now go in for a vote. All those in favor say aye.
Aye.
Aye. All opposed say nay. Is there no opposition? The motion passes. Are there any discussions in the matter before we move on?
I just have a question. Does Commissioner make these online?
Yes, Tina's working on it with her to get back in.
Oh, okay. I just didn't hear her vote.
She did message, she's present.
If there are no questions, we move on to the next topic. And that would be the Administrative Director's report.
Thank you, Mr. Chairman. CLTC received a FOIA request on July 30, 2026 from Mr. Billy Sablan and/or Billy Mendiola regarding GICC's meeting with it's regarding documents, GICC documents. We also had a meeting with Department of Agriculture, Forest Rehabilitation Plan, and Habitat Conservation Plan to discuss the proposed MOA between CLTC and the Department of Agriculture that was on August 5th, 2026. July 22nd, 2026, CLTC staff, planner Tom Torres, and PC Dexter Tarrant, accompanied by Management 1, Damian Narcis, and interns, or summer interns, Isabella and Sol, met with Ms. Clementine Schnabel from UOG, CIS, and SG and PD. She's working together with Mayor Alec, Fran Castro, UOG, CIS, and SG Associate Director, and Joshua Munya, Guam Restoration of Watersheds. This is in regard to a board meeting where the mayor was present and requesting for property for a program. They are working with the University of Guam. Governor's Summer Youth Employment Program ended July 31st. a luncheon and simple ceremony with awarding the certificate of participation by myself and the chairman, and a short presentation by the interns, Isabel Kinata and Sol Cruz. Their parents were also present. Status of lots 440-4 and 440-5 in Molesso. This is the Trans World property. A police report was filed on behalf of DLM regarding a break-in to the facility. Several AC units were removed and the electrical wiring were stripped of copper wires. CLTC staff, headed by Mr. Glenier, secured the property by replacing doorknobs and replacing padlocks to the entrance gate. On August 17, 2026, I'm pleased to announce that Mr. Joseph B. Cruz, his reemployment, we reemployed him, sorry. And then on August 6th, we received the sad news on the passing of Lydia, our land agent 1. And then finally, not in that report that I gave you, but there has been numerous meetings with DLM on the transfer of the Transworld property, a lot up in Dedido. This is block 16, and then 10 lots adjacent to that on block 12, 1113. Is it lot 1113? Track 1113. So those transfers are almost complete. We have a final draft on the block 16, and DLM is just finalizing the transfer of the other 2 properties. So I expect that to happen very soon. Regarding the residential and agriculture applications, we reported at the CLTC board meeting on July 16th. Applicants based on their date and time, there were 200 approved by the board. 50 were mailed out. I believe were mailed out. 50 applications are currently in the review process, and we still have 100 pending review. Under commercial subcommittee meeting held with GMA on July 29th, 2026 to discuss the draft lease agreement, and also a subcommittee meeting held with GICC and Power Solutions to clarify the request for a term of a 30-year lease.
So what was the outcome of the discussion on item 3B?
So Mr. Carlos Camacho will be joining us. Mr. Carlos Camacho will be joining us, and that's on the agenda. So
Okay, so we can discuss it at that time.
yes. Then the appraisal contract for services submitted by Milo Appraisal Group for the GICC was signed on July 31st. Commencement of the work is pending, the settlement of payment by GICC. So I'm pleased to announce that that contract was signed. Subcommittee meeting held with Guam Housing Corporation to revive the 2014 Memorandum of Agreement with CLTC. D.A.G. Miller prepared a draft license agreement. During the meeting, all parties agreed to revert back to the original 2014 MOA with updates on it. And that completes my report, Mr. Chairman.
I have a question.
Sure.
On the FOIA request,
Sure.
it seems that there's 2 names floating around on that same FOIA request.
That's correct, sir.
Can I require that if a FOIA comes in, that we verify their legal names? Because it's showing under Sablan and also Mendiola.
That was taken up with the AG, and the response was that we just respond to the FOIA. We just respond to the FOIA, so we did.
But we don't know who's requesting it, whether it's Sablon or.
So we
Mendola.
addressed it to
I mean,
both.
both names were intermixed in that request.
So just to cover ourselves, we addressed it to both, Mr. Billy Sablan and Billy Mendiola.
But is there a vehicle for us to require that they show us proof that that is their name?
No, according to them, so the staff got clarification from Miller, and we're just to respond to these FOIA requests and not to question, right?
That was a question that I was going around in my mind, because when I initially saw the FOIA, it was Mendiola.
I was
Now
hoping,
in this in your report, it's Sablon.
well, it's actually, because both names showed up in the FOIA
But they're
request.
both Billy Mendiola and Billy Sablon. I think that's one and the same.
It's two different names, so we addressed it to both. I was hoping that we could require them to come in, but that's not an option either.
So just a general FOIA question, because a lot of times the requests will produce voluminous paper. Is there, with regard to the law, is there a way that do we charge them, or can we provide it to them in an electronic format? You know, how is this provided? How is the information provided to them for this particular request?
Electronically, because the request came in electronically.
Okay, so if they send us an email asking for, you know, information, we can also just send it electronically. We don't have to print out. Okay. What if they request it for a hard copy?
Can I just make a clarification on
Sure.
that? We did have to print out the documents, right?
Okay.
To scan and respond to this, because, you know, it was emails and the lease and other types of documents. So we did print them out. So I can't say that it was at no cost to CLTC. There was, in addition, time of staff putting this together.
So can you just, you know, later on, look into the law and see what are the requirements, what are the commission's requirements? I mean, I know that other agencies also have this situation. It just seems that, you know, a lot of the information that we provide is, you know, voluminous in regard to paper.
Sure.
I do believe if it's a certain volume, there's a fee schedule.
Yeah,
Okay,
Yeah.
yeah.
But
At a
we'd have
certain
to-
point, you're
yeah.
right. At a certain point.
Okay, so just as long as we communicate it to them so that they need to pay that fee. I want to make sure that we enforce that.
Correct.
Okay.
Any other questions? If not, we move on to the next item of the agenda. Old business is going to take up quite some time. Can we do new business first? Because it's just constituent matters, and I foresee that it's not going to be very lengthy. So we'll go into constituent matters first.
Sorry, Dexter, we're gonna do the constituent matters.
Maybe to address the ones that
We're
are
gonna do-
present, right?
So maybe
Yeah.
Glenn.
So do you have to make a
And
motion?
No, we'll just go.
Damien,
Okay.
Eileen, and Jessica.
These are all the constituent matters. That's what we-
So no, we don't need to make a motion. Okay,
So, Mr. Chair, we're gonna go ahead and move to new business. So do we need to make a motion to?
do we need to make a motion?
If,
I make a motion to proceed to item number 6 on the agenda, new business.
On second.
motion has been made and second. All in favor, say aye.
Aye.
All opposed, nay. Ms. McPeace?
Aye.
Okay. All opposed, say nay. Is there no opposition? The motion passes.
So, Mr. Chair, the first constituent matter is Elizabeth Mendiola Hudson. And we have Jessica Dede, Land Agent 3, to present.
Is anyone present for? Oh.
Would you like to speak? Sure.
You can have a seat here, and then you can sign in with Mr.
This is Mr. William Hudson. Okay, so Commissioners, the case that I have before you is Elizabeth Mendiola Hudson. She has a residential application. Yes. So Miss Elizabeth Hudson is deceased, and this is her husband, William M. Hudson. Mr. Hudson is formally appealing the May 28, 2026 motion that resulted in the removal of his wife, Elizabeth Mendiola Hudson, from the award listing. Let's see there. Where's the rest? So William Hudson is formally appealing the board's motion passed on May 28, 2026 to remove Elizabeth Mendiola Hudson's application from the award listing. According to his appeal, Mr. Hudson previously visited CLTC office with Mrs. Hudson's death certificate, marriage certificate to address advertisement and file a claim. During this visit, he was informed by a CLTC employee that he was not recognized as the successor to Mrs. Hudson's application and could not receive any information regarding her file. The guidance is the approval or disapproval of the appeal regarding to the motion to remove Elizabeth Mendiola Hudson's application based on Title 5, Chapter 9 of the Guam Code Annotated Administrative Adjudication Law, subsection 9235A. The agency may order a reconsideration of all or part of the case on its own motion or petition of any party. The power to order a reconsideration shall expire 30 days after the delivery or mailing of a decision to the respondent, or on the date set by the agency as the effective date of the decision, if such date occurs prior to the expiration of the 30-day period. If action is not taken on the petition within the time allowed for ordering reconsideration, the petition shall be deemed denied. So what this is she was a part of the batch 5, I believe, of the December 2nd, 1995. And we did a mail out. There was no response, obviously, because she's deceased, but Mr. Hudson did come in within the time that we mailed out the letter, the 90-day notice. He did come in, and he wanted to find out information, but I guess due to he wasn't the named successor. However,
So are they married? It doesn't say anything here that they're married.
He brought in a marriage certificate.
he does have a marriage certificate. He did bring his marriage certificate and her
So Mr.
death.
Hudson is the husband.
Correct.
Was there a named successor?
There was
Actually, two.
2 named successors.
A daughter and a son, I believe.
Yes.
However, anything prior to April 2024, there was a public law that was passed that you can name a successor to an application. Prior to that, prior to April 2024, it wasn't, I guess, allowed to name a successor on applications. But after that public law, then that's when you're able to.
And she did name a successor.
She did, but
afterwards,
then, because it was before that, prior to that public law, in April of 2024, moving forward, Mr. Hudson did prove he was the next of kin. He proved that he was the spouse.
So how do we fix this?
So,
He's
Your decision.
The removal of, his deceased spouse, Elizabeth Mendiola Hudson. He's appealing the removal, so I think that the request is to,
Reverse that motion?
reverse it.
Okay.
He, right after the meeting, he did submit the letter within 30 days of the decision
So
that
he
you
met
made.
the criteria that,
So was he aware at the time when we met in May, was he aware, did we inform him that his wife's name was to be entertained?
He was aware,
Okay.
the first time, then the meeting was canceled due to, I believe, the storm.
Right.
And then the daughters were the ones who came in. One of them did come in prior to the day before the meeting. I'm not sure, it was a conversation between the land agent and her. And unfortunately, the land agent is not here, so.
So I guess my question is, prior to the meeting, prior to us, this board making that decision on May 28th, were we aware that he did not want his wife to be removed?
Yes,
We were aware.
yes.
So then why, is it in our minutes? Was it brought up in our minutes at
No.
all, that we had a prior conversation right up to the meeting that, so that we should not have entertained it?
The formal,
Correct.
the formal request came in on August 10th. He came in prior to
Okay,
the meeting, correct? He came in prior to the board.
to the May 28th
Yeah.
meeting?
This meeting,
Okay.
yes, I came by.
Whose name is on the lease?
There's no lease, it's an application. She's ready for a lease award.
But
She's up for a lease
Whose
award.
name is on the application?
His wife, Elizabeth Mendiola
Not Mr.
Hudson.
and Mrs.?
No, it's not. He's just coming in because he is the spouse, the widow,
Were they married at the
Widow.
time that
yes.
the application was,
Yes.
okay, they were. It doesn't say when they were married, okay. So I guess what it is I'm trying to backtrack to avoid this situation from occurring again. If we know that an applicant's name is going to appear before the board, and someone in the applicant's family or the applicant themselves presents themselves to the commission, there should have been something reported so that the board, we wouldn't have made this decision, and then now 2 months later, we're coming back to reverse it.
But there's
It's
also
my-
a process of an appeal.
Okay, so well, it was my there is a process of the appeal, but that's my whole thing, is that the process of the appeal is when there's information that was not known to us, but it was already known to the staff. From what I'm hearing, it was known to the staff that he wanted to remove his wife's name from the delineation listing and proceed in another manner. So you see what I mean? We're actually doing double work.
Right.
So, I don't like to see that, because it's wasting your time. Mr. Hudson has to appear again, he had to go through the process of writing an appeal. Why does he have to do that? I mean, he already expresses his concern that, hey, my wife died, I have her death certificate, and this is what I wanna do, and we should have taken action based on that. So I'm sorry, Mr. Hudson, that you have to come back and appear again at the end of August. I think that this situation could have rectified itself, and we could have taken care of it sooner rather than later.
No, I thank you for that saying, I thank you for that, and like you said, let it not happen again.
Yeah.
We all make
So,
mistakes, but
just so
I
that,
thank you for that.
we're aware, and we
Yes.
can use our time more wisely.
But my concern is, a successor was named.
Right.
Did we get any feedback from the successors?
So the daughter was the one of the named successors, which was the daughter, she did come in the day before the meeting. The
And
day
what did she
before
say?
that it was canceled.
Did she provide any testimony or anything?
No, the meeting was canceled.
No, but she didn't provide anything.
No, she just came in and said she was the named successor, and we informed her that it's gonna go before the board.
So because Mr. Hudson was not a successor, I think the staff interpreted it as they could not respond to him. And so one daughter comes in, she's not the successor, they didn't respond to her either. The second daughter comes in, she's a successor, and that's how information was given to the family.
Yes.
I don't have a problem with granting Mr. Hudson what he's asking for. My only concern is the liability because there were successors named. And in
Well-
the back of my head right now, I'm thinking if there was a successor, they may,
Want
they
to
may
exercise.
come back to us and say.
However, but the time that she named the successor, in an application stage was not allowed
So it
until
was-
April 2024.
So it was a null appointment then?
Correct. So now he would have been he's the next of
Next
kin
of
because
kin.
he's a widow.
So he would be the next, I guess basically the next successor or the successor because,
And he's also requesting to be the named successor.
right? Okay.
Maybe the question is does this create any conflict with the children, right?
Is it creating a conflict?
I don't know.
No,
Well, we did
no,
speak to
I
the
spoke to my
kids, yeah.
kids, and they said it's fine if I take over the, application.
Would they be
It'll be
able to
okay.
submit something in writing
An
to that
affidavit or
effect, just for
something.
our comfort level?
Sure, yes, I can
Yeah,
have them,
if that can be provided, I don't have any questions on that matter.
okay,
We can resolve it.
all right.
So maybe I can make a motion to reverse the removal, subject to the submission of the affidavits.
I have a concern. Well, one of the successors, my son,
Did they?
had a heart attack, stroke, so I'm wondering how is that now?
Is he alive?
Yes, he's still alive, he's still,
Okay.
But
would he be able to?
Does he have a guardian?
I mean,
Is
No,
he-
he's of age already.
Oh,
Okay,
Okay.
but he's capable
He's-
to execute
Legal
a
document?
legal
his mind
document?
is clear.
Would that be,
Yes, I mean,
okay,
if
yeah.
if he's capable
Yeah.
to execute a legal document, then yes.
As long as he's mentally competent.
Plus
Um,
plus you would have to relinquish your successor claim. If your grandson you're talking about?
No, my son,
So if your son wants to take over?
yeah.
Oh, okay. So then you would just have to relinquish your successor claim.
If he wants to take over, okay, because his name is there.
Well, like
But
I mentioned, it's
I
voided.
thought there was no successors applicable at that point in
Correct.
time.
But because he's the widow, he's the next of kin, he would have to relinquish his successor claim, because he has rights to the
No, but
application.
he wants to take the claim.
No, he said that his son.
No,
Do you wanna give it to
I
your
was,
son or do you wanna take it?
No, I wanna take over, but I was, when you guys asked for documents or a piece of paper, having them relinquish their successor.
Right, yeah, so they would all just need to sign.
Yeah, I was just stating my son had, is sick, heart attack, so what, I'm just trying to, how do I go about that now? Because I know my daughter can, but with my
Yeah.
son,
Yeah, as long as he's mentally, as long as he understands what he's signing,
okay,
then you should be fine.
okay.
Yeah.
Yeah, I don't wanna relinquish my successor, I wanna take over my late wife's applicant, if I can, if that's possible.
So, Mr. Chair, I'd like to make a motion to reverse the May 28th decision to remove Elizabeth Mendiola Hudson from the residential application listing, to reinstate her name with the requirement that the children of Elizabeth Mendiola Hudson submit affidavits stating they're okay to relinquish any interest they have in the application
To their father.
to their father, relinquish to their father.
I second the motion.
A motion has been made and seconded. We'll go in for a vote now. All those in favor say aye.
Aye.
All opposed? Since there's no opposition, the motion carries. Congratulations.
Thank you, board.
You're welcome. Thank you for coming in.
Yes. So, have a good day.
Okay, so the next one we have is Melissa Shell Tucson. But we're requesting if you can just, remove her from the agenda.
Why?
I'm sorry, because we got, guidance from our attorney stating that it can be done administratively.
So we're gonna propose to the board in another meeting,
Right.
giving the authority for those requesting termination. If it's a voluntary termination, if you could just give me the authority, but we'll put that on the September meeting.
But do you already possess that authority to do so?
I think it's just to be clear, it's probably a good idea to do a resolution, and that's by legal guidance.
Okay, but you do have the authority and you're just asking for a resolution to,
Well, when somebody requests their interest in terminating, I don't see why we would deny it, right?
yes.
So,
So I guess, in the interest of time, in the interest of the board time, and also, just to stick to the letter of the law, if the law allows that, and you have the authority to do that, then I think that you should do it. I don't, I don't wanna see things on the agenda, and I think I've said this numerous times. If something can be handled administratively, you have the authority to do it, and that's why we have these rules and regs, and please handle it.
there are a couple of things that we are gonna come to the board, and this, just for clarity, and just because, at some point, the board will change and I will move on, and at least it's clear.
But the law, the law protects you, it's clear in the law.
Yeah. I don't think anybody would, disagree, right, when somebody voluntarily terminates.
So
on the
again,
action.
if it's within the law, I think that you should do it. Again, I do not wanna see anything on the agenda that, the law has already given you the authority to do that. I don't like to see directors coming to the board for every single little thing. We're not here to micromanage you, I'm not here to, run your day-to-day
Yeah.
life. You need to handle things administratively. If it's within the law, then please do it.
Commissioner
Yeah, I
Espicio,
just-
so the thing was, the previous director had
Okay.
had
Done it,
approved
yeah.
it. So it was just never removed, so that's why we were gonna bring it to the board, just to have it,
Official.
official.
So,
But then you just said that the Attorney General said that he, that
Later,
was
yeah,
within
that
his
was
rights.
later,
Okay.
when we had our meeting just recently, that's when we just realized that.
Okay,
So
so
we don't need
Can
to
I
deal
have
with
a
this.
comment? The law is very clear that, in cancellation of the lease, it has to go to the board for approval. But it doesn't mention, they mention if they're gonna cancel application. This is why we're here today, trying to clarify
So there's a
that.
difference between lease
Yeah,
and
and
application?
application, yes.
Okay, so
And application
what does Attorney Miller say? Because there, like you said, there's a lease and application. This person, this is application. So what did Attorney Miller say?
So anybody turns in a written request to withdraw,
Okay,
they're able to.
okay, an application.
Application only,
Okay, so
no,
make
if they have a
sure
lease or not,
that you
yeah.
have that legal opinion in your file so that when our director, whether it be Ms. Angela Camacho or anyone else, they have that in the file that says, hey, I have the authority to do it, so I'm gonna do it.
But he also mentioned in the same email that, we should do this in a resolution. So
Yes.
it won't just be this one issue, there will be other things that we're going to request.
Okay, can you please forward that email? I just,
Sure.
I know that you want to, I just feel like, why do we have to double check? And, it just seems that,
We'll send that
okay,
to
double
you.
check, but then we just had a constituent where we knew of information, but then we didn't actually do anything with it, you know what I mean? So I really wanna put the onus on the staff to, function as they should. We're not here to, again, I'm not here to regulate your day-to-day operations, things that are, required board approval should come to the board. If it doesn't require board approval, then it shouldn't be on the agenda.
So
so-
when the
yeah.
agenda was put out, it was already,
Yeah.
so the thing is,
I
anything
understand
that's
why
not
we're
in the
moving
law.
now, but what I'm saying
Yeah.
is, the request to add it to the next agenda, I don't necessarily agree with that.
It's not gonna be this issue.
Yes,
Yeah.
okay, so if it's not this issue and it's other issues, fine. So with regard specifically to this
We'll
issue,
handle
thank you.
so we don't need to take any action on this?
that. No,
Okay,
So, okay,
Yeah.
just wanna make sure, cause, if it's necessary, let's just
Do
take
it.
care of it and be done with it.
nothing needed.
You sure?
okay,
Okay.
okay, thank you.
So the next item under new business and constituent matters is the case of Yvonne M.G. Blas.
So Ms. Bloss has an agriculture application and she's deceased. She is the next one in line. She's the next one in line for a lease award. Clarissa K.G. Roy.
Is she
I'm not
present?
sure if she's present.
Is she present?
Ms. Roy? I don't know her. Okay, so Clarissa K.G. Roy requests that the board approve her as an eligible beneficiary. And another, second is Ms. Roy also requests that the board approve her as a named successor to her mother Yvonne M.G. Bloss's application dated December 2nd, 1995. So
So we need
Miss,
to,
okay.
go ahead, clerk.
Ms. Roy has submitted supporting documentation establishing her as the goddaughter, oh, I'm sorry.
Granddaughter.
Granddaughter.
She's supposed to be daughter. I mean granddaughter.
It does say granddaughter.
Yeah, granddaughter of Rose Gutierrez Guzman, the ostensible landowner of lot 1413-1 in Agana, which is acquired by the United States government under civil case number 43-58. Furthermore, Ms. Roy has expressed her intent to assume her mother Yvonne M.G. Bloss's application. And the guidance is the approval of Clarissa K.G. Roy as an eligible beneficiary are supported by Guam Code Annotated, Title 21 Guam Code Annotated, Chapter 75A, subsection 75A 101.2. The approval of Clarissa K.G. Roy as the named successor and to take over Yvonne M.G. Bloss' agriculture application is supported by Title 21 GCA, Chapter 75A, subsection 75A 109.
So we just need to approve her as an eligible beneficiary and approve her to be the named successor.
Yes.
Mr. Chair, I'd like to make a motion to approve Clarissa K.G. Roy as an eligible beneficiary and approve her to be named as a successor to take over Yvonne M.G. Bloss's agricultural application to the CLTC.
A motion has been made, and we get a second.
I second it.
A motion has been made and second, we now go in for a vote. All those in favor say aye.
Aye.
All opposed say nay. Since there's no opposition to the motion passes.
Okay, thank you.
Thank you too.
So, Mr. Chair, we should move to old business now. First item is Guam International Country Club, and I believe we have Mr. Carlos Camacho online, but I would like to call Dexter.
Can I get I would like to skip down to item E because it's, I don't think it's gonna take that long for us to discuss it and approve it as compared to A through D and F and G.
I make a motion to move to item 5 in the agenda, old business, item E.
I'll second.
Okay, motion has been made and second. Can we go in for a vote? All those in favor say aye.
Aye.
All opposed say nay. Since there is no opposition, the motion carries. We begin with item E.
So, Mr. Chairman, item E is Public Law 37-146, funding Cliffline Full Cartel, and I believe we have representatives from the Equivia family. I saw it. Come on up and come on up. Both of you can actually join us. Mr. Chairman, we'll have Dexter Tan present.
Please sign and state your name.
Edwin Eclavera.
Doreen Borman.
Good afternoon, Mr. Chairman, Commissioners. For item number E on new old business, Public Law 37-146, Carbon Cliff Line Bull Cart Trail. On May 15, 2026, Cornerstone Valuation Guam Inc. produced a market valuation conclusion of $152,000. I just wanted to correct the dates of the submission of Milo Appraisal Group. Is supposed to show April 27, 2026. Okay. The market value conclusion for Milo Appraisal is $17,000. Due to the large volume of the document, the office has already emailed the full packet to the commissioners for their review. I also wanted to inform the board that both appraisal companies have satisfied the agreed upon scope of work that was required from them. To determine the price of the Bull Cart Trail, we will take the average of both appraisals, which comes out to $84,850. That amount will serve as the fair market value for the 1,580 plus minus square meters identified as the Bull Cart Trail traversing through lots 5045, 5045-B, and 5051-B on the Tagusan Road, Municipality of Tanin.
What was the Cornerstone appraisal?
Cornerstone appraisal was $152,000, sir.
And
So,
Milo?
Mr. Chair, just to be clear though, the reason for the appraisals is for the Eclavea family to acquire the Bull Cart Trail.
Yes.
And the Milo appraisal?
$17,000.
And the average?
Average is $84,850.
Any questions?
Can I just say something? When Cornerstone was questioned about why their appraisal for that property was that much of a difference, from my understanding is because they appraised it like a regular sized lot. Bull Cart Trail was a narrow road. It's 1,580 square meters. So that I can see is the difference about how the two commercial appraisers were able to appraise that property. And that's quite a difference between the two appraisals.
So, may I bring up a point though? This was brought to our attention. We did inform the family that because they were the ones that hired the appraisers, paid for the appraisal, that it was for them to bring up any questions, any discrepancies with the appraisers. It's not our position to interfere with the appraisal report or with the appraisal.
So, ADD Camacho, when we take a look at the law doesn't specifically say anything about us, about the board choosing the highest, the lowest, or taking an average. It just basically says that if there's a requirement for two appraisals to accompany it that authorizes. So it doesn't really give the board any direction or guidance as to the selection of the appraisal, correct? And that's how I'm reading it. So I just wanted to know, Mr. Dexter Tan, you did, on your summary, you did do an average.
Yes, ma'am.
What is your reasoning for that?
Well, based on our mandate, the appraisals is supposed to be conducted by 3 appraisal companies.
Yes.
But since one appraisal company could not perform the appraisal because their appraiser passed away, so now they only have the option of the 2 appraisals.
Oh,
Which is
so-
Cornerstone.
Yeah,
Yes,
so
yeah.
they, okay. Why is that? Oh, because of the zoning of the property? Because it's a zone H? Because there's a lot of other appraisers out there. Couldn't they have just
No,
got?
because
It's commercial.
Yeah, because it's commercial. Okay,
Yes,
so that's why
ma'am.
my question, because of the zoning.
Yes, ma'am.
Okay.
well, actually, the property is a hotel.
Yeah, it's zone
But,
H.
I mean, we're evaluating this, information, you know, based on the appraisals, but did you ask Cornerstone to look at the property as a road rather than,
Yes, that's what I just mentioned, that when they were questioned about their methodology, and the summary was, they did the appraisal like a regular size lot, not a road.
so they're not willing to go back and look at it
No.
as a road?
They-
We
The family did, okay. Well, it says here the appraiser is not required to explain or testify. Well, what my thoughts are on this, on the appraisal specifically, is that, when you do an appraisal for commercial property, there's always, different ways to approach the property, and one of it is highest and best use, right? What is the functional utility of the property? And also, what are the conditions, the limiting marketable conditions? So just, in my background, when I think of those things and I look at Cornerstone valuation, I've just, as Mrs. Borja, mentioned here, I'm kind of puzzled as to why they took that, perspective or that stance in evaluating the Bull Car Trail. Because when you take a look at the functionality, it's really only for one function. It's not as if anyone else can go and just purchase the Bull Car Trail for the purpose of what? To go from point A to point B? You know what I mean? There's really no, there's no ROI on that. If we put this Bull Car Trail on the market, and I'm an investor, or any investor, as a matter of fact, they're gonna take a look at, well, what is my ROI? What is my return on my investment? I'm just gonna use it to go from point A to point B, and I'm gonna invest 100 and, what was that?
52,000?
Yeah, 52,000, and it's a dirt road, so I'm just, I'm not satisfied with, the way Cornerstone appraised that property. And then, of course, then we have Milo appraising it, so I think that, what the staff did by taking the average is probably the best, methodology that the board can use or that the staff can use, because it's such a wide range. And we're not appraisal experts, we can only go by the information presented to us by the experts. And I think that that would be the most, reasonable conclusion, is to do the average.
And again, because the family was not able to get Cornerstone to reconsider their method, I think it's probably fair to say that this is a fair way of looking at it based on what's presented before.
Correct.
May I ask,
Yeah.
based on your experience and your knowledge of, best use and return on investment, et cetera, and the fact that, you already stated that, this appraisal from Cornerstone seems very high and, in my opinion, inaccurate. Can we ask that the board, based on that, not utilize that appraisal and base it on the one for mine? Is
Part
that
of the
within the
problem
board's
is the,
capability? Can you guys make that decision, or?
I think part of the problem is that the statute requires that we work off of two
Yeah.
And I don't
appraisals.
think that we can conclude that it's inaccurate. I don't
Right.
think that any of us are qualified to say,
Right.
and I'm talking about this side, you can have your own opinion, but I don't think it's fair of us to represent either appraisal inaccurate.
Correct.
Just for, my experience, I acquired over 50 lots, for rights of ways when I was in Public Works. In regards to, appraisal and appraisal review, this is why there's always have to be a third party, which is the appraisal reviewer. that reviewer will review both sides and check their comps to see where to get your comps and from what resources, because when you're gonna do a comp, you have to go from the closest sale of the property and not and work your way out. That's how you do your comps. So it's not going to be determined on the commission, it will be on the reviewer. And as for the Bukai Trail, they're treated like group property. That's why he did that.
But to your point, the family did go back to Cornerstone to ask them to reconsider, because, and I think it's fair, when you come up with appraisers so wide in value, so different, I think it's fair, and I would probably do the same thing myself, but they would not reconsider their methodology.
They can go back and reevaluate.
Sometimes they do, sometimes, I've seen it
They're
where,
going to stick to their.
Well, in this case, they did not
They did
want
not.
to.
Yeah.
Yeah.
Um,
Cornerstone,
Both appraisers are at the same certification level.
Yes.
And the disparity between the two is very great, and it's something that we're gonna have to resolve here. And the path of least resistance right now would be what is being suggested by COTC staff.
Yeah,
And I-
Rich?
yeah, I think that to Mr. A's comment, that both appraisers did look at the property as real property, because they are real property. I don't think that they, looked at it in any other way. It's their methodology of approaching the real property. That there's a difference, and it's not to say who's right or who's wrong. As our chairman mentioned, they are both credentialed and, very reputable companies. The law provides us to take a look at two appraisals, and, rather than selecting either or, I think that the best way to move forward, now that it's a path of least resistance, is to take the average as suggested by the staff.
Well, we really don't have much of a choice since there's no third party to oversee the two appraisers, so.
There doesn't necessarily need to be a third party to oversee the appraisers, and that's not what's required by the law that brought us here today, to have an appraisal review, And it's not, in a lot of cases, you don't even have a appraisal review. It's what the appraiser says, and then that's it. And unfortunately, there's not a third appraiser that we can say, hey, we don't like this, let's go get another one. Because it's a limited, limited license.
Yeah.
It's specific to the license based on the zoning of the property.
And it would not be cost efficient for you to hire off-island appraiser.
Yeah.
Yeah, I guess with that in consideration, I guess what we can offer is that amount of 84,000, right, 850. Yeah, unfortunately, with the way the statute was written, our hands are kind of tied dealing with the two available appraisals or appraisers.
So if the suggestion by the staff for the average is acceptable to the family, then I would request the board to make a motion regarding the amount that was suggested. If they don't have any other questions.
So my question too would be, is there any other way to reduce that, other than what we've discussed here today?
Unfortunately, it's by law.
Yeah,
I just gotta
Yeah,
ask.
I know,
just-
I know,
yeah.
and that's
Yeah.
so, that's a good question, so that's what I'm trying to clarify, is that we wanna go, we wanna follow the law, which we're doing, we got two appraisers. Unfortunately, there's such a huge disparity, and we choose one, oh, why did you choose that? We choose the other, oh, why did you choose that? They have two different methodologies, that's what I see reading the reports. And I think that the best solution would be to take the average. Just kind of meet them in the middle road. In the
If you
middle of
ruled
the
on that
road.
today and we go in that direction, if, let's just say tomorrow, whatever the case may be, something came about and we're able to get a reviewer,
Yeah.
is that something that can be brought back and reviewed?
I think it would be another appraisal, but,
Right.
So we'd have to go through the whole
We
appraisal
don't have
process
to,
again?
if you're not satisfied with these appraisals, sir, we don't have to use this, we don't have to make a decision today, we don't have, the book cart
understand.
trail, yeah, will stay as is. If you desire to get another appraiser, you can do so, considering that they have the correct credentials to appraise
Right,
this
understood.
property. So if you wanna go up island and find somebody, or, that's fine, or we can table this, you don't have to, we don't have to make a decision based on these two appraisals. If you don't feel happy with the appraisal,
But if you do find another appraiser, the danger that you run into there is if that other appraiser comes in with a higher amount, it could drive the price up.
Understood.
Yeah.
My question is, I guess, if we go in this direction and a decision is made, okay, the board decides, okay, we'll follow the recommendations and sell the property back to our family for $84,850. If after that decision is made, and whatever, a week, 2 weeks goes down the road and we found somebody, or we determine that we can go another route and maybe get it reviewed, is that something we can bring back to the
I don't think a
person?
review is an option, I think another appraisal would be an option to you,
Right.
and
but I don't know, is there a, what is that called, an appeal process? Once we make a decision on this, would there be an appeal process? Because this is different from the prior case that you heard, right? So once a decision is made on this, I'm not sure if there even is an appeal process.
So that's what I'm.
Yeah, so if you don't want us to make the decision today, we don't have to, you can discuss that with your attorney, discuss that with, the director, the assistant director, the acting director, and we can come back again
That's
another
okay,
time.
we'll withdraw that.
Yeah, so it's entirely up to the family.
I just wanted to ask and find
Yeah.
out, and it
Yeah.
seems like we just don't know, so
Yeah.
we're not trying to delay anything.
Right,
Sure.
I just want to bring out too that if you do decide to hire outside appraiser other than Guam, they have to be a licensed appraiser in Guam as well.
I just said that,
Yeah.
Just,
yeah.
please note that.
So
Understood.
we'll go ahead and, yes, accept the decision. And my question would be how soon, what's the next step?
You can talk to the director after the meeting, yeah, she
Alright.
can tell you the process.
I think if a decision is made on what has been discussed tonight and is ratified by the board, I think everything after that is administrative.
Mr. Chair, I'd like to make a motion to accept the average of the two submitted appraisals at $84,850 as the sale price for the Boca Trail within lot 5045, lot 5045B, and lot 5051B, Tangisan Road, Chamoru.
Motion has been made, can I get a second, please?
I second the motion.
Motion has been made and second, we're now going for a vote. Somebody say something?
No.
All in favor, say aye.
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 All opposed, nay. Since there's no opposition, the motion passes. Congratulations.
Thank you.
Thank you.
so
Uh,
Mr. Chair.
At this point, I'd like to take a 5-minute break. 6:30 PM, Thursday, August 27. Our board meeting resumes.
Okay, Mr. Chairman, the next item on the agenda under old business is Guam International Country Club. We have Dexter here to present.
So for item A, Guam International Country Club, our office received a letter from Mr. Carlos Camacho, the authorized agent for GICC on August 3rd, 2026. A copy of that letter has been provided in your meeting packet. The letter is regarding the good faith escrow deposit of minimum accelerated rent pending final MAI appraisal. GICC is requesting for the board's concurrence to deposit into escrow the amount of $950,000, which is equal to the 10% of the minimum accelerated rent. Joining us on Zoom is Mr. Carlos Camacho, if the board has any questions.
Hi Dexter, I'll just wait till someone asks me a question.
I'm sorry, before we turn it over, I also want to mention that we received a letter this morning regarding GICC, so I think that there are two items that,
I was wondering what that was.
yeah.
Oh, okay.
Okay, so we can deal with the first matter and then review this, or?
Yeah,
Yes.
okay.
Okay. So this is the minimum deposit for the, on the 10%, or minimum, or the 10% deposit of the accelerated rent, right?
Yes, and until we get the appraisal report, which I don't expect for another 60, perhaps 90 days, because that extends beyond the 30 days after their PPA.
Yeah.
So we're gonna go off of the minimum, amount of 9.5.
I believe this is their good faith effort.
Right, the good faith, yeah, yes,
solution.
okay.
So-
So, go ahead.
No, so is it, Mr. Camacho, is your request just to put 950,000 as a good faith payment and not put the 9.5 million? Is that what your request is?
Yes,
Because What I'm thinking is, we know that
we're
nine.
gonna be compliant with,
Okay,
the law, the 3861, that, referred to a floor rate of 9.5 million. And of course, for many months, we've been trying to figure out the appraisal side, as you guys, I've been to many meetings with you guys via Zoom. But finally, that was done. And then, unfortunately, there's a 30-day window once a PPA is signed, which we're almost there. I think it's gonna be signed in 10 days, but I can't confirm that. As you guys know, in that Q&A meeting, I provided the Attorney General's final approval that was sent to GPA, and now they're working on the final PPA. Once that's signed, then the 30-day clock kicks in. But for good faith, what we wanted to do, as we stated in that letter, is based on the floor rate on the law, the 9.5 million, we'll put the 950,000 in escrow, and once, number one, once the PPA is signed, and let's say there's no appraisal yet, right, then we can release that 950,000, right? And then let's say 30 days later, an appraisal comes in and it goes more than the 9.5 million, as I stated in a Q&A session, who will pay the delta? Or if the appraisal comes below 9.5 million, we will still stick to the 9.5 million as based on the statute on Public Law 3861. So it can go left, it can go right, we don't know, but right now we want to show good faith that we are still committed based on Public Law 3861, and put that in escrow, and then the trigger would be the PPA to release that.
So,
Is that clear enough?
so yeah, so just to clarify, the law only requires that 10% be made within 30 days after the execution of the PPA, right? So you're just saying, let us put $950,000 because the minimum is 9.5, but if it comes up higher, you'll pay the difference when that appraisal comes in.
That's correct.
okay.
Okay.
And vice versa, if it comes, we don't know until the appraisal comes. I just heard you guys about some appraisal, but at the end of the day, we don't know if it will go left or go right. If it goes up, like I said, we do commit to pay the delta, right? The difference from, the 9.5 plus whatever the additional value comes up. But if it goes below the 9.5, we're still gonna, pay the rate based on the statutory minimum requirement. We're not gonna argue that it's lower and that we just go with based on the statutory. So we just wanna put that in good faith to show that, we wanna be in compliance as we always stated, but, that's what we're doing. We're gonna put it in escrow, then we'll give you a copy of the escrow receipt that the money's been deposited, after the PPA signed, it was deposited, and we don't need to wait 30 days, because it says after PPA, 30 days. Unfortunately, the appraisal might not be ready or ready, then you can do both at the same time. But we're willing to release the $950 after the PPA signed.
So do we need a motion for that?
I just have a question, if I may. Mr. Camacho, the escrow
Yes.
company would be chosen by GICC.
Yeah, will we deposit their escrow? Yes. On behalf of the escrow, when we open the escrow, it'll be for, this is based on Public Law 3061, based on the floor rate of 10%. And so we'll put that in our put note of the escrow, and to be released once the PPA is signed within that 30 days. But like I said, we wanted to show that in good faith, so we don't have to wait. That's what I heard the director said, acting director said, it probably may take 90 days. I don't know if that's correct or not, but 90 days from the day you guys kicked off that appraisal will exceed the 30 days based on the statutory 30-day requirement. So that's why we wanted to just make sure we're within compliance and at least show that we're still moving forward and would like to make the deposit. Yes, and that will be escrow deposit in favor. I think we could do that. I gotta give escrow instruction in favor of CHamoru Land Trust once we give instruction to be released once the PPA is signed. So I know every time I open an escrow and all my real estate dealings, we also have to provide escrow instruction to release to which party. In this case, that money goes to CHamoru Land Trust Commission based on Public Law 3861.
Whoever has the best rate. Well, I don't know if it'll be a conflict if we go with Pataco.
Okay.
Is there, may I ask, is there a preference, or did you determine already what escrow company?
We don't talk about that.
There's only 3 in Guam, by the way, so all 3 have the same standards. You got security title, you got title guarantee, then you got Pacific American title, right? So we haven't decided. One of them will have it, and we'll give it a copy, whoever we open the escrow with.
But that's gonna be your decision.
Yeah, because,
Usually
you know,
by
escrow's
choice.
that is the third neutral party, and they will hold the funds until whatever we gave instructions are met. And we'll give you a copy of that instruction when we open the escrow to show that once PPA is signed, and we're within the 30 days, we'll get to release that funds, even if the appraisal's not here yet.
ADD Camacho, can you just look into our rules and regs and see if there's a specific escrow company that the government uses, or can we, you know, to Mr. Camacho's point, can he just select any of the 3, or, you know, I don't know how that works. Just Mr. Camacho, because I don't want you to open escrow and then for some reason it would be null and void because of our rules and regs. So Ms. Camacho is going to investigate that and get back to you as to which escrow company is acceptable to the government. Because I don't know, to the government.
Don't forget, it's coming from a third party, which is us, and we're gonna be providing escrow
You're
instruction
not the third
to
party,
be
the
to release
second
to a
party.
government, which is based on Public Law 3861.
Yes,
So
and
the
what-
account is under a private organization, that got the lease, and we're just complying with 3861, but you're more than welcome to investigate it and give me notice, whichever escrow company you guys want to open.
Yeah,
Uh,
my question was just to make sure that, to see if there was a preferred escrow company that the government uses. I don't want you to open escrow with one company and for whatever reason, the government, you know, doesn't use that company. I don't know if this goes, you know what I mean? I just wanna make sure that, just to, avoid duplication of efforts in cancellation or anything. Anyway, Ms. Camacho will get back to you on which escrow
No
company.
problem. Just let us know, at least,
Or if it's just your choice, then it's your choice, then it's buyer's choice,
I think we can figure it out within a week.
yeah.
yeah, no problem. And then, I just wanted to ratify that letter, as stated in the letter that we wanted board approval based on this strategic, idea of how we're gonna fund the funds. So we make sure that, you know, there's money sitting in one of the escrow companies. Whichever you guys, if you guys choose one, then just let us know. But there's only 3 on the island, just to let you guys know.
I mean, if we were gonna do it, we'd probably have to go through the, procurement process, right? We get 3 quotes or something.
Well, we're not the ones
No.
depositing the funds, it's their
Oh, it's their-
fund,
okay,
so-
so I don't think there's a procurement issue here, I just think to the Commissioner Vespacio's point, it's their preferred escrow company used by, and I think we'll just ask DOE.
Yeah,
Yeah, just to, I just, you know, I don't want them to open escrow with one company and then, oh, we don't do business with, you know.
We always hear vendors, so we'll just confirm
Yeah.
that they're vendors.
Oh, there you go, they have to be a vendor.
Yeah, maybe, yeah, that's right, the way, the same way I recall, remember Mr. Joey Cruz said they gotta be a licensed vendor of DOA.
Right.
So you gotta check, maybe all 3 are, but I don't know. I
Right.
never checked that.
Okay,
Well, I do know that security title is, because I've done a transaction
with them,
with
okay,
government of
she'll
Guam
get
and
back to
security
you,
title, but we'll confirm
thank
on
you.
the other 2.
sure. So we need a
No
motion.
problem, we just wanted to show good faith that, we're trying to comply with, Public Law 3861.
Yeah, so we just need a motion to accept the 10%, good faith deposit at a minimum of 950,000
Into escrow.
into escrow. Mr. Chair, I'd like to make a motion to approve for GICC to make the initial 10% deposit into escrow as a good faith deposit.
One
Subject,
moment, Mr. Camacho has something to say.
I don't wanna interrupt, am I able to talk based on Jeremy's motion?
But
I just wanna clarify
Not yet.
that is the correct motion, but I want to make sure it's clear that we're still gonna be waiting for the appraisal, and whatever the delta is, positive or negative, right? If it's positive, we will pay the additional 10% once that appraisal is
There's no
completed,
negative.
if it's positive. Just wanted to make sure.
yeah, I was about to add, subject to the appraisal. Yeah.
Okay, I'm sorry,
No,
just
no,
wanna
it's
make sure it's clear.
It's okay. Okay, Mr. Chair, I'd like to make a motion to approve for the minimum of $950,000 as a 10% good faith deposit into escrow, subject to the completion of the appraisal by the MAI appraiser.
I second the motion.
A motion has been made and second. We now go in for a vote. All those in
Oh, I'm
favor
sorry,
say aye.
Mr. Chair. I think maybe it's Commissioner Makepeace that wanted to say something?
Commissioner?
I totally agree with my other commissioners, so.
Okay.
Okay. All those in favor say aye.
Aye.
Aye, already.
All opposed say nay. Since there's no opposition, the motion passes. Congratulations, Mr. Camacho. Thank you for the
Thank
money.
you.
I guess before we move on, I think Director Camacho brought up the letter that was submitted and
Today, this morning.
today, yeah.
Okay.
So, if there's any other, Mr. Camacho, do you have, I guess, input on regarding the letter submitted today?
Yes, if I can explain that letter. On Tuesday, August 25th, on Guam, there was a public hearing on bill number 305-38. I know in the past you guys met with the author on just a briefing on 30538 at the COTC office. They finally had the public hearing on August 25th, 2026, and that is just related to the commercial leases and commercial licenses that they'll have a financial framework. And that bill was just basically authorizing and codifying the same law, Public Law 10638, which is one code annotated 5128, which we use for GICC's previous board meeting approval to get the 3 years. But what had happened when we decided at that time to use either option 1 or 2, that it be signed by the chairman and acting director Camacho, or number 2, that it be signed by Attorney General Doug Moylan and GICC and Governor Governor Lula Ongaro. That was the 2 option. Dexter, and I recall it, that was July 14th, he said he sent that letter to attorney, you guys rep, Attorney Norman Miller, right? And Norman Miller brought back, as he's been consistent since March, but this bill came into play on March 27th. He was consistent that you do need legislative approval. But what happened when he said that in March 19th, 2026, or March 27, 2026, Public Law 10638 became law through an override, and that allows any government agency that has commercial leases to extend the lease up to 15 years as long as you meet 2 criteria. You're in compliance and you're in good standings, which at that time, when that was March, April, I'm not sure if we got delayed in April because, was there a storm in April? I forget, but so many storms coming. And one of those stuff that got delayed and delayed. So I finally, again, testified to provide our compliance reasoning why we think we're in compliance. Because everything we owe historically, and any economic business, as I stated in that same public hearing, there's ups and downs in the economy, but we never ran away from our debt. We always paid it off. The biggest one was COVID-19, where we owed $900,000, and the whole community and our opponents also say that's too much money they owe. But fortunately, the previous board, under Chairman Regis, and Mr. Garrido was a board member then at that time, Arlene Berdalio, and I think what's his name, Mr. Herrera, and Angie Camacho was the acting director then at that time. We went in and asked at that time for a waiver because the government was shut down to an executive order due to COVID-19. But because your statute did not allow that, we then asked for a payment plan. And I recall when we got approved for the payment plan, at that time, board member Earl Garrido said, we'll give you a 3 months probationary period to either continue the payment plan and continue your rent. If you are behind from that point, we will then consider terminating the GICC lease. Very straightforward condition. Well, from that point, from his recommended condition, forward, we paid everything into place. We're never behind, right? Even though the market's so soft, we made sure we did that. But what we did at that time, we asked for an economic diversification as one of the conditions, because the golf course industry was not financially healthy. As you guys saw historically in 2014 present, that's why we wanted to do a diversification on the economic use. And that's where we're at today. And from that point, I guess we were able to catch up in our payment. And as per Public Law 36.1, the first compliant requirement is to pay off your arrears. That was the first check ceremony we had. Once Public Law 36.1 was done, we had, again, within 30 days, we're going to pay off the 227,000 balance of the 900. So we did that. And then after that, we had to create the lease, which we did. And then at that time, we incorporated Attorney General Doug Moylan, GICC, and Governor Liu. The only reason, again, as I cleared in previous meetings, why we threw those names to be part of the signature, this was a very hot topic throughout the island So my opponents was saying that we shouldn't get it because we owe 900,000. This was a special interest. I don't know how special my client's been owning that property since 2014. We're not a new player, right? So at the end of the day, we finally got all through that cycle, and we made it through that when the governor signed it. And the reason, like I said, we had the Attorney General sign it, so nobody would think that that was a special interest because we got all parties to sign it.
Mr.
But your
Camacho?
statute, as our legal opinion said in the previous meeting,
Sorry,
you do not
Mr.
need the
Camacho.
Attorney General to sign and the governor, because your statute only allows the chairman and the acting director.
Mr. Camacho, I'm
So-
sorry to cut you off. There's a 3-minute limit because we have other constituents that's also waiting to be entertained.
So.
I'm sorry, is that Dexter talking?
Yes, sir. I'm sorry to cut you off, sir, but there's a 3-minute limit because we have other
Oh, I'm
constituents
sorry.
also. Yes, sir.
Okay. So, okay, let me just get back to the bill.
Yes, sir.
So 305 is there, and we only got 7 days based after the hearing, which ends September 1, and I wanted to re-ratify Attorney Miller's concern about legislative approval. So our legal team decided to draft an amendment on 3061 to be added to this bill so that it will be in compliance to his request. In parallel, the Attorney General is still reviewing his legal opinion and research, and if that goes through before this bill passes, then at least we have 2 pathways. But I do not want to miss the opportunity to miss the Tuesday deadline, September 1. That's why I decided to put this in, and we are going to submit this, hopefully with your concurrence. And if you read it, it's everything that's the same thing what you guys approved. We're not asking more than 2,058, and everything's there. Other than what I threw in at the tail end of that is if there's an accident, natural disaster, as I keep saying in all my meetings, that if that delays us for 6 months, 1 year, then we can come back to the board to ask for that reprieve. As you know, since March to forward, we had Sinlaku and Bobby and all that kind of stuff, and more typhoons looks like it's coming. But we just put that as a safeguard, so I hope I can get your support to provide a letter. I'm not sure if you're gonna have to wait to adopt that letter in the next minutes in September. I know there's a procedure, but if not, then if I can get that letter on it before September 1, because I'll be submitting this amendment to the legislature to comply with their 7-day timeline on submitting that in testimony. So, sorry I exceeded the 3 minutes. Dexter, thank you for reminding me. I apologize.
So just to clarify, you're gonna be submitting an amendment to this,
Public law.
this,
Bill.
bill to, to amend the public law that 5128, is that correct?
3861.
3861?
No, public law 3861.
Oh, I'm sorry,
section
public law
2.
3861. All right, and you're gonna submit an amendment and you're asking us to submit support for that amendment?
Yeah, if you could, I mean,
Okay.
it's just consistent of what your legal counsel, Attorney Norman Miller's been asking since March, and since every time, we're trying to do other things, but I think I said, okay, I'll submit one since we are now going through the legislative process, and in parallel, we'll wait for the Attorney General to finish his legal research and opinion, and we'll see which one comes first.
Okay, so Director Camacho, if we made a motion to, if all the commissioners agree to support, could we have a letter out by Monday? I mean, because I know normally when we,
If I may, Mr. Chairman, Commissioners, I think before we proceed in supporting Mr. Camacho's request, I just want to make sure that the board is aware of Bill 30538 and what entails, what's in that bill.
30538.
So the chairman,
Where-
this is
what-
the one that the chairman testified in jail?
That's the one he testified on Tuesday on his personal account, not
Capacity.
capacity,
So what does
not
Bill
represent.
30538 have to do with this? Is it here? Where
It's
is
an
it?
amendment.
Commissioner for
I can.
Okay.
3538 relates to extensions for commercial and commercial licenses. So our attorney verified with the legal counsel that this is germane because our stuff is commercial related to that property, to that bill. If it's not germane, then I cannot submit it.
But
For
it,
example, if I'm
it
submitting
has
something
federal, you
housing
have to have
related,
federal.
and this bill's only commercial, it's non-germane. Since our request is a commercial
They
related
mentioned
amendment,
commercial
it is
finance.
germane.
Okay, I'm sorry, Dexter, can you please further explain what is the relevance of the bill that you're mentioning to Mr. Camacho's request?
He wanted the board to write a support,
Letter in support.
letter of support
Of Public Law
because,
3861.
for Bill 30, for he's requesting to amend, Public Law 3861.
Okay.
Bill
And
30
that's what it says here, that's what
Yes,
he's
ma'am.
asking us to support, Bill 3861.
Yes,
So what
He
bill are
meant-
you talking?
Again, I'm not asking.
Excuse me, Mr.
I'm
Camacho,
not asking
Mr.
for
Camacho,
Bill
Mr. Camacho,
3538.
Mr.
Only the
Camacho.
amendment I'm submitting, that's it.
Yeah, I think what he's
Yeah.
saying is he's asking us to support the amendment that would be made to Bill 305, but it would be specifically effective to
38.
Public Law 3861.
Okay, so
So
I don't-
we don't specifically need to support 305?
Yeah, that's what I'm saying is, you're bringing up something that's not in his letter, so I wanna know what is the relevance of that. If there's no relevance, don't bring it up. So I'm asking you, Dexter, what is the relevance of Bill 305 to this?
305, Bill 305-38 is regarding financing,
Okay,
allowing, commercial, sorry, there you go.
okay,
Let me just read the title of the bill. So Bill 305-38 is an act to add a new subsection 75A 122, Chapter 75A, Article 1, Title 21, Guam Code annotated relative to financing driven extension of commercial ground lease terms for new and existing commercial leases and licenses for all types of financing and all underwriting requirements, including but not limited to federally assisted or federally insured financing.
okay, so this is regarding financing of the leases. What Mr. Camacho is talking about is Public Law 3861, which
So-
is,
And it also.
that's about the extension, right?
Yes.
So this bill
Yeah.
allows for up to 40 years.
Okay,
If a commercial, if a company is going out to financing on government property, then it extends it up to 40 years,
okay,
Additional 40 years.
not additional 40
I mean,
years.
total up to
yeah.
40
Okay,
years, yes.
Yeah,
So-
but this amendment would be kind of like a rider on that 305, but specific to Public Law 3861, right? Is that correct, Mr. Camacho?
Yeah, if you look at 305, 305,
so this
that's
amendment is
38.
for 305.
There's two sections there that's being adopted. They're adopting, Public Law 10638, one code annotated subsection 5128, which is what you guys used to approve me. We're incorporating that in that chapter because that was required for us to move forward in our financing and in our development. And that's what you guys did when I presented our compliant and good standing, and you guys used that. But Attorney Miller, of course, with respect to his opinion, he said we did not have the authority to use that because it was not in our lease. It's not in our 3861. So we look at my amendment that I'm proposing, it has, we're not asking for up to the 15 years, we're only asking what you guys granted, up to
Yeah.
2058 from 255 to 3 years, as you guys granted. And of course, the option 2 years, that was already there in the law. The only thing I add different is that this will be applicable to 5128, right? If in the event there is a acts of God, natural disaster, and any, it didn't say pandemic, but any other type of medical type of delays. That's it, but that's what we're doing. We're just
But the
now
amendment is only
incorporating
specifically to
5128
GICC.
in there.
It's only specifically to
That
renewable
when Mr.
energy.
Miller made comments in the past that 5128 does not comply with our 3861. So now that 30538 is codifying section 5128 as part of your chapter, right? Before it was not, now it's part of your chapter. That way you guys have the authority to any other commercial tenants who's in good standings and compliant that may need financial, as long as they show that they got their finances in order to build their commercial building, whoever that may be. Because when you stabilize that commercial, that's where the financing mechanism there. You guys stabilize your cash flow for your mission and goal. That's the whole intention. So I testified in favor of those two components, right? And for your commercial tenant and your, what you call it, commercial license. I did see Mr. Garrido as an individual, not acting as the chairperson, because he did claim, because I was there in the same meeting via Zoom, right? He did claim that the board did not yet approve or whatever for this bill. He made a couple of concerns, and he can disclose it to you guys. One of them is the SUDA, that it left it open that, how can you make us finances without identifying our resources? So after that meeting, the Senate sponsored bill is incorporating, to my knowledge, because I'm working on the bill now, to say that the SUDA loan program that's there also will be subject to the board discretion and subject to funding availability. If you guys don't have the funds, then you guys won't do the SUDA. That's the safeguard that we're doing on behalf of Mr. Garrido as an individual when he asked that question.
2 minutes, okay.
That's it. I don't want to go over 3 minutes, but at the end of the day, you guys are not supporting 30538. You're supporting my amendment to the, which I'm going to include on that. And we don't know, like I said in my letter, we don't know if the senators will adopt it on the markup. If they don't, then I'm back to waiting for Attorney General's legal opinion and research. But if it, according to them, is germane, if it is germane because it's related to commercial or commercial licenses, right, then it'll be incorporated. Then you got still the last hurrah where it gets reported to the floor and we don't know if it'll be voted on or voted down. That we don't know. We can't predict that.
So I have a question. There's another attachment, Article 8. What is the purpose of Article 8? It's regarding long-term subleases.
No, this is a portion of the GMA lease. It was.
Oh,
yeah.
I'm sorry. I was like, I was trying to. so
Also, I
this
just
doesn't-
want
This doesn't belong here.
Yeah.
Yeah. I also want to inform the board that the testimony that the chairman gave to the legislature on Tuesday, he was, on his personal capacity, he was against Bill 30538. He informed the panel, the senators, that the board has not had an opportunity to discuss 30538, and there's no collective decision or motion from the board regarding this bill. That's the reason why I brought up that the board should review and make a decision regarding the bill before what is the board stand on Bill 30538.
So I can see where he's going with the amendment, because it's what has been suggested by the AG several times. With regard to Bill 305, I'm not too familiar with it, so I mean, I have to do more research, but I can support an amendment that specifically addresses our.
You can support my amendment only, and you can say that the board will still want to review the whole bill on 30538, and of course you missed the window to submit any comments, but you can submit other comments, because when they put it on the floor, then they can debate what needs, if they don't, according to that meeting, when Earl Carrillo was there independently, yes, he said, I'm reserved because the board didn't do this, but as an individual, I got two concerns, right? And hopefully if they, now that he made that a statement, when they do the markup, hopefully they answer that question. So when the bill comes back as a markup to you guys to review, right? So you guys couldn't comment by September 1, there's no way to submit, that's the deadline, right? Then when you review it, and when Earl reviews it as chairman now, to look at his 2 points that he brought up, did they resolve my 2 points that I asked? You know what I mean? That, and then you guys can either say, we don't like the bill or we like the bill, you know? But at least I know I cannot miss the September 1 to me to submit this. If I don't submit this, then I don't have access to submit any 3861 amendment opportunity, so we can comply with Attorney Norman Miller's multiple requests.
I know in the past we did the resolution to extend the 3 years, right?
Mm-hmm.
So, I mean, is that something that's feasible? Could we do that? Just support the amendment to Bill 305 and not necessarily the entirety of the bill. I'm not sure if the rest of the commission would be amicable to that, but
I think that the request is specific to the,
Proposed amendment.
The
to
proposed
the proposed
amendment, yeah.
amendment. So I think that it's reasonable to say that the board can write testimony in support of the amendment, which actually supports our previous actions
right,
from two prior board meetings. So we would just be basically reinforcing our decision.
right.
And then, of course, when 30538 goes entirely to the legislature, they do their picking and choosing, right?
Yeah, because for all we know, they may not
Yeah.
accept
Could
it.
I add one more thing from Mr. Gomez, Commissioner? If you did a resolution format other than a letter format, based on my experience with Dexter, a resolution format cannot be given until it's adopted in your September 17th board meeting, the minutes. Then a resolution is written, which you guys will be way over the deadline.
I think he's referring to the resolution
Oh, yeah.
that the board
No,
already made.
well, what I was saying is in the past, we've made a resolution to approve the 3 years. So this is in line with that. So I guess what I was saying was, you know, I'd be supportive of a letter to support that specific amendment that would, I guess, reinforce our decision in the past to do the resolution. But I'd be reserved about specifically writing a letter in support of just Bill 305.
Okay, so you're gonna put that in
And I'm okay with that, for respect to your guys' position to review the final markup version. And hopefully, on the markup version, you'll probably see this amendment. You'll hopefully see, when he's acting as an individual, Mr. Earl Garrido's amendment as he requested in order for him to move forward to support it. I mean, those are the things why we have to go through the public hearing process. So it's recorded and requested and it's marked up. And the problem I have is I only got to September 1 to submit mine. But if you guys are not ready to do the letter, I am still gonna submit it so I can make the critical timeline of September 1. And hopefully they may say, you got support by the CHamoru Land Trust? Then you guys can probably write a letter after. You don't have to do one by September 1. You can do it after that if you want. But I'm just letting you know, for all courtesy, this is what I'm doing.
Mr. Chair, I'd like to make a motion to support, to write a letter of support for the amendment as proposed by GICC, specific to Public Law 3861, which would further support the resolution the board voted on in a previous board meeting, commission meeting. But again, specific to Public Law 3861 and not necessarily to support Bill 305-38. And at which time we could make, where we can make further, I guess, further decisions with regard to this support of Bill 35-38 after more research by the commission.
Motion has been made. Can I get a second, please?
I second the motion.
Motion has been made and second. Now we go in for a vote. All those in favor say aye.
Aye.
All opposed say nay. Since there's no opposition to the motion, the motion carries.
Mr. Chair, can I make a modification to my motion? Just that the letter be submitted by, what date is Monday? The 31st, on or before the 31st. Do I need to restate it?
Go ahead and restate it.
Okay. Mr. Chair, I'd like to restate my motion for the commission to draft a letter in support of the proposed amendment, which would make a change to Public Law 38-61, specifically to that, and not specifically supporting Bill 35-38.
305.
305-38, subject to further research by the commission on 305-38, with the letter in support of the amendment to be submitted to the legislature on or before August 31st.
Can you clarify that this will supersede the prior?
Oh, this motion will supersede my prior motion.
Okay, a motion has been made. Can I get a second,
I
please?
second the motion.
Motion has been made and second. Now we go in for a vote. All those in favor, say aye.
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 All opposed, say nay. There's no opposition to the motion carries. You now go to the next item in the agenda.
I'm gonna stay on just to watch.
Thank you, Mr. Chair. The next item on the agenda is Guam Motorsports Association, GMA. We have Mr. Hans Ara and Mr. Jambers Jr. Let's get approach to the table and sign in, please.
Gentlemen.
Good afternoon. Thank you for having us.
Thank you. Okay. Before I proceed, an update was given to your packet. The one with the highlight. Okay.
That was the
That will be the
Article 8.
Yeah, Article 8.
Okay.
Yeah, okay. So a subcommittee meeting was held on July 29 with the Guam Motorsports Association, and the draft lease agreement that is in your packet is the result of the discussion between both parties. On August 20, a request for an update to Article 8, subsection 3 regarding long-term sublease was received and sent to legal counsel for review. A copy of it has been provided for you today. Of course, we have the representative with us to discuss further the GMA draft lease agreement.
Did they get copies of this?
They're the ones who submitted it, yes. I gave it to them.
Okay.
Can I actually see one of these? Yeah, just make sure it's the same.
So this was the final
Correct.
change, right?
Yes,
So-
this was the final change we received from CLTC.
Right, right.
Yeah.
Okay.
Perhaps we can read it for the record, the final change. Do you want to go ahead?
Article 8, subsection 3, long-term subleases. Any proposed sublease lasting more than 30 days, long-term sublease, requires the CLTC's prior written approval before lessee enters into the sublease. Lessee shall provide CLTC with a copy of the proposed long-term sublease for review and approval. CLTC agrees to schedule a meeting to approve or disapprove a long-term sublease within 90 days of receiving a complete long-term sublease from the lessee. Before CLTC decides whether to approve the proposal, the parties shall discuss whether CLTC will receive a share of the sublease rent, or also called a participation rent. If CLTC approves a long-term sublease without requiring participation rent, CLTC waives any later claim to participation rent for the approved sublease.
So we're good to go with the lease as it is.
Yeah, yeah, we've discussed it with our board members and, we'll accept if you will.
We're ready to go?
So,
You ready to go?
Yes, sir.
That's good news.
so the final lease we have here was based on the last subcommittee meeting we had. I think we've ironed out all our differences. Yeah, so, Mr. Chair, I'd like to make a motion to approve signing the lease for the for lot 7161-R1 Jigo Guam. with the Guam Motorsports Association.
Motion has been made. Can I get a second, please?
I second the motion.
Motion has been made and second. We now go in for a vote.
Any discussion?
Huh?
Discussion? Yes. Can I add a point?
Sure.
Sir? On page 10, Article 11, 11.3 and 11.3 and then 11.3A. I just want to clarify reasonable advance notice. Typically, landlord advance notice is 24 to 48 hours. I just think that it's an important detail to put in there, what reasonable advance notice is, because you may not be around, we for sure may not be around. And, you know, the future parties, I think, should have boundaries. So, I don't think that we need to agree this here, but
Sure.
between yourself and our representative, if you can agree, either 24 or 48 hours, I think is the standard, the reasonable advance notice.
We agree?
That's it.
Yeah.
Okay.
Okay, you can put that in,
We can plug it in 24 hours?
Sure.
Yes. Okay.
Sure.
okay? That's it.
All those in favor, say aye.
Aye.
All opposed, say nay. Since there's no opposition, the motion carries. Congratulations.
Congratulations, gentlemen.
Long road.
Thank you. All right, thank you. If I may,
Let's go make winners.
exactly. The next step, what's the next step in
We can
signing?
discuss that with,
Sorry.
yeah.
We gotta schedule the signing and all
Yeah,
that.
the final document will be prepared and then they'll schedule for signatures and all.
Awesome.
Congratulations again, it's been a long road.
Oh, yeah. Thank you guys for your time and the effort that you guys put in. We really do appreciate it. Thank you.
Good luck.
For all the hard work.
Oh, yes. Thank you guys. All right. All right. Thank you guys. Wow. It's a lot more than I thought. If I can, shake everybody's hand. Do appreciate it. Mr. Grado, I think it's been 3 years in the making. Thank you. Hung in there. One of the last ones. Thank you. Everybody, thank you. Thank you. Working with friends. So we'll talk more. 3 years. Yes, sir.
Glad to finally concluded with, it was win-win. You're welcome. Good luck.
I did.
I'll stick around to 3:45.
Let's just do the police department.
Yeah, yeah.
Agree?
Okay, yeah.
Okay.
Mr. Chair, the next item on the list is Guam Police Department, and we have Glenn Lee to present. And then if we can call Guam Police to join us at the table.
Okay.
Is it just you?
Well, I guess, yeah. Thank you. I signed it over, but I guess I signed it. Okay.
Have we talked about this use before? Is this the radio barographic one?
Yeah, that's the old business, no.
There's so
We
much
discussed that.
discovery since then, so we'll present that.
Okay, no, but is this lot, is this the lot that was mandated by the legislature?
No.
This is a different lot, okay.
It's come before us before, we did some research and had been provided additional documentation, so that's what we'll be presenting today.
Okay.
Stand in and state your name, please.
If
Okay,
you can
we're
state
ready?
your name, yeah.
Okay. For the CHamoru Land Trust Commission members, my name is Major Fred Charlotte, and I'm currently the Services Bureau Chief for the Guam Police Department.
Kenyon Shamron with Motorola, we're the contractor for the Guam Police Department for this project.
Okay, I'll go ahead and start. Again, my name is Major Charlotte, and in this capacity, one of the areas of responsibility that I oversee is the Services Bureau which includes the tactical communications section that handles our public safety dispatch and communications. I'm here today to provide testimony in the old business regarding GPD's request for the lease, license, and access of easement for the Barragata Heights property. GPD is currently performing upgrades to our communications apparatus. One of the upgrades is to construct a new generator shelter at the site in question. The shelter will provide backup power for our mobile communications amongst our officers. As we are all aware of the load sharing occurring as we speak, this critical infrastructure will provide continuous communications amongst our officers as they respond to calls for service. We are requesting a letter of authorization from this board, which would allow us to work with the Department of Land Management for building permit approval immediately to avoid losing vital federal funding and jeopardize the completion of this ongoing project. We are requesting that the board grant approval for easement on the property and addressing the lease at a later date. Granting this request will allow the department to move forward with the permitting process to initiate the construction. Granting the easement permit is vital because the funding for the shelter will be utilizing is ARPA funds that is set to expire in December of 2026. Additionally, we are seeking consideration to grant us the entire property and not just a portion. The surrounding perimeter security of the area is vitally important because the area contains equipment that is part of the island's critical infrastructure, which is communications, our communications. The vision is to create a centralized shared public safety communications hub shared with the Guam Fire Department and possibly even other essential services dispatch capabilities that could streamline shared communication and coordination on a daily basis or in a time of critical emergency response. So to kind of summarize that, I know that the meeting is specifically right for the lease, but because we're trying to build this generator shelter, and the purpose for it, of course, is to have backup power. And again, the communications part, these are the guys that are on patrol using their radios, responding to the calls and the emergencies and everything. So what this does is that when we have power outages or, like I just mentioned, load sharing, it'll provide continuous power. So that's the purpose for the shelter. But again, what we need to, I guess, fast track, right, is approval from the board, the commission here, to grant us, the links to get the construction moving. So that's
the request to grant right of entry, so that way that can be used for the building permit, while
Right.
GPD and the commission works out a formal site usage agreement or
Right.
some type of apparatus.
So there's an existing antenna
yes,
on
on the site.
on the site, 11-1.
So there's a communication shelter and a 100-foot tower
Yes.
that's been there since early 90s, 80s
Right.
timeframe.
Yeah, early 90s.
So what I'm reading here and getting from him is he needs easement to at least construct what they need now.
Right.
And then later on, we're gonna address the surrounding area with the lease.
Yes.
Is that correct?
Yes, so, in our last meeting, the board instructed, the staff, the management to find, a way how we can handle and move forward,
Right.
to either commercial lease or commercial license or a grant of easement. And of course, it was made mention in our, board meeting that,
What board meeting?
May 28th?
This board?
Yes,
Yes,
correct.
May 28th,
That's fine.
2026.
Okay.
That's in the, that's in my, and
So
that
is
should
that
be
what
there.
this is, the
Yeah.
meeting minutes?
Yes, it's there. So the board mentioned that, for the management to find a way how we can move forward, either by, establishing a commercial, either license or lease.
Right.
Like a grant of easement, and of course, I mentioned also that there was, first place, how did GPD get there, and it had, they mentioned, I mentioned that they've been there for over 30 years, and there was no documents that, puts them in that place. only recently, 2 weeks ago, I found a document, an MOA signed by Lieutenant Governor, Acting Lieutenant Governor Ray Tenorio, and the most recent one on March 2021, MOA, it was revised by our governor now, puts them, allowing them to occupy that area.
So the MOA was pretty vague.
Vague?
It just identified a village, didn't identify a lot. And I
Lot.
think that that's the challenge
Yeah.
that they're having in moving forward with the construction of
right.
this thing. And so, I'll let Glenn finish.
So, yeah, like Director said, that, it just put the municipality, Baragara, and Tigua, and other places, but didn't describe a lot, description. And although it's an MOA approved by the government of Guam and Joint Region Marianas, okay?
There's just no specific description of what property it is.
Right, just say Baragara, but we
Right.
know it's Baragara Heights, because
Some
that's
village.
where the city is at. Yeah, we can
Say the
assume,
whole
right?
village, yeah.
We can assume. They're gonna put up a photo, because of the area that's where subject we're talking about. I took some photos. There's an area of that antenna, which you're able to,
Is that in our?
okay. That should be there in your package.
So, before you proceed, I just have a question. So they have something that's existing there, because you mentioned board meeting, and I have the
Yeah.
meeting minutes here.
Yeah.
I think one of the things that's very important for this board is that we remain consistent in the type of decisions that we're making, right?
Right.
So I think that we've been kind of reiterating that. So according to the board minutes, thank you for including that. With regard to this request for the right-of-way, it specifically says that GPD was instructed to get the property recorded, then CLTC can move forward and grant the right-of-way. And then a commissioner made a motion to instruct CLT management to develop in conjunction with GPD a lease, license, or other instrument as deemed necessary, right?
Yes,
This
that
is
was-
with regard to this lot, right?
Yes.
Because when they first appeared to us, as stated here, there's no formal lease or license agreement.
Right.
Okay, so are they coming to the board asking for the same thing that they came to in May?
Oh,
That's what I'm seeing. They're asking again for us to overlook the fact that they've been there for so long.
no, they're not asking to
So
do
what do they
that.
want?
Yeah,
No.
so, since that meeting in May, Glenn has been working very hard to, establish even how they got there to begin with, because that
Right.
would be the starting point, right?
For the
What-
lease.
What,
Yeah.
what allowed them, because I think there's even power at the property.
Yes.
Yeah.
And so GPA hooked up power,
Yeah.
but what's the documentation anyways?
Right.
It
To
was a big.
support their presence.
It was a
Right.
big mystery. And then the best we could come up with the assistance of Guam Police, and then also Glenn was in touch with JRM,
Yeah.
Joint Region Marianas.
Mhm.
And the MOA that was executed is the best that we can come up with.
Okay.
And
To the
because
other
it's so vague, I think, and now we traced it to CLTC property. I think that's why we bring it before the board.
Was it
Yeah.
even CLTC property at the time that it was built?
Before we existed.
Yeah,
Yeah, it was
so-
prior to,
Right,
We weren't,
yeah.
Yes,
So-
the governor of Guam could have easily approved that somehow, right?
right,
Now,
somehow,
wait a
but,
minute, the first signature was Ray Tenorio.
He was-
So, go ahead.
well, so, there's an MOA, memorandum of understanding, that allowed, government of Guam allowed, Guam Region Marianas to be on that property. And in return, government of Guam was also to use, Joint Marianas, region antenna sites as well. So it was like co-sharing antennas.
Right.
You use mine, I can use yours, there were conditions and everything. And this is, signed by the Attorney General, the Admiral, the Acting Lieutenant Governor, and Acting Governor at that time, and with all agencies besides CLTC, because
What year was that MOU?
started in 2016,
Okay.
and then the revised one in 2021 by our present governor.
So,
Okay, so,
so what allowed them to be established there prior to 2016?
There's no records of that, sir. This is, like I said, there was just MOA that I just recently discovered, found 2 weeks ago, that actually puts them there. There's also a map in like 2016 that identifies GPD there and that, in that location, but there's no document supporting that. It was just a master plan.
so you see where we're at is that we have a tenant occupying property that CLTC owns, but there's really no legal pathway for them to like technically be there. Should anything happen, liability-wise, where would that fall? On CLTC? Yes, sir?
Just aside from the MOA that was
Yeah.
executed, right, which we were not a party of.
Okay.
Um,
So somebody else decided, okay, you can use CLTC property, here's the MOA, powers above the CLTC.
You could put it that way.
Okay,
yes.
so I'm just drawing the map.
Yeah.
So what I'm coming to is that you see all that mess that was created? Why? Because they didn't go through the proper channels. So that's why I'm coming back to our meeting in May. What was the direction from the board? Get it straight, right? Get it straight. Get a lease in place, give them the legal authority to say, hey, we have a paper that says that you can really be here, and then we can do the right of way. Why are we gonna why are we gonna continue to create a mess of this mess already? We're
We're not-
adding, hot dog and everything into the spaghetti.
We're,
That's what I see. Am I not,
if you're
that's
looking
not
at the
right?
big picture
Okay.
right now, if you're looking at the bigger picture right now, there's an ARPA fund right now that that allows them to.
There's a what?
ARPA, there's just
Okay, okay.
so there's a deadline to meet, okay?
Okay.
So, right now, so what they're asking right now is a grant of easement right now to allow them to continue.
But where,
And,
okay.
can
No,
I
my-
finish?
no, I know.
Can I finish?
I wanna go back to you started
then
with the
in-
lease.
in-
Where
in
are we with
lieu
the
of
lease?
that,
Have you even started
We
the
can
lease?
work on getting a lease or license.
Yeah.
So
I was speaking,
we're gonna
okay?
make a recommendation.
It's a recommendation.
We're gonna make a recommendation.
We're not here to say
to
you're
the
gonna
board.
get a commercial lease. They're making a proposal right now to get a grant of easement and so that we can work onto getting a lease or license. We also want to consider a grant of easement, and based on the MOA that was already in place by the governor and everybody else. And if you read the MOA, it says that they have 9 years to remain on the property. So if, I want to finish, okay? So the 9 years, and the remaining of the 9 years,
Go ahead.
I'm sorry, I got to finish this.
Glenn, just
Yeah.
let the chairman has a point, if you don't mind.
Okay,
There's no one here in this board that does not want to help GPD, okay? That's not the question. The question right now is like, we are putting the cart in front of the donkey. Something transpired in the past, it needs to be rectified, but we cannot just, like I said, put the cart in front of the donkey instead of the donkey pulling the cart.
we're not doing that, sir, we're not. This is why we're
Because
here.
we don't have a lease or a license.
Yeah,
This
and
is why
so,
we're
and so
here.
that's why, yeah, what we're bringing to the board is a suggestion. And that is to grant, the right of easement to the Guam Police Department. The tower is already there.
So my question is, they don't have a right of easement. They're already doing business there. So they should just continue to do business there. They don't need us to
This
grant
is
the right of
about,
easement,
this
right?
is about,
Because they're already there.
but this is about, putting a structure to protect a generator. And that's the request, is they're just asking to,
They're asking for an easement to put a structure. Okay, but that's my whole point is their entire structure is not really like,
it was sanctioned, I think, even prior to the existence of CHamoru. No,
so
it's
that's
not.
that's.
It's not, this happened prior, and the
Not
tower's been there
It was
prior
an MOU.
to.
More just your
Yeah.
property.
Yeah.
30 years, yeah.
So they've been there 30 years
But the MOU
already,
was
prior
in
to our
2016.
existence.
Yeah,
Yeah.
so,
They've been there prior.
yeah.
Yeah.
So what I'm gathering here is like, the reason they're asking for the easement right now is because the ARPA funds expire in December.
Right.
It's the same
And they're-
funds that we've been granted during the pandemic, right? So we don't use those funds, we lose it. So what they're asking for is the grant of easement to be able to build it prior to expiration of the funds. And then we deal with rectifying the issues of the lease
So my
afterwards.
question is.
Is that correct?
Yes,
Yes.
and also I want to add to, and one of the biggest questions when you're asking is why are we here and everything. It was like sometime in March or early part of March when they went through the process of the permitting process to build the generator. They went through land management and other agencies to get a permit to construct the generator. Only to find out that there was a red flag at DLM. They says, oh, wait a minute, this is, you don't have a lease or a license, you're not, are you there? This is why we're here today. They tried to do that, go forward, but it was red flag at land management, because they didn't have a lease or license.
When was
on the
that,
property.
when was that?
That was
red-
like
red flag?
March.
Just March of this year?
Yeah.
Land management told you that you don't have a lease to be there?
Correct.
Yeah.
So then we were set for the April meeting with
So,
CHamoru Land
my
Trust, but that
question
was
is,
tabled due to the typhoon.
Because of their, I guess my whole point is, there were already existing buildings there, somehow they were funded and they were there already. So my question is, what does the grant of right-of-way have to do with the ARPA funds? You already have the right-of-way because you have an MOU that's been allowing you to be there, correct?
So in order to get a building permit and get the clearance from Department of Land Management, they need some documentation that shows that there is authorization for a GPD to be on that
So
property.
isn't the authorization through the MOA?
It only says Barragata, look, it's just the village, it just identifies.
Municipality of Barragata is all it says.
there's
Doesn't give
no-
a specific
Oh,
law.
so now DPW is deciding that they want to put down their foot and follow the rules and have some kind of a lot
I
number.
don't wanna.
Because prior to that, they've already allowed them to go there and put up their antenna, put electricity and all of that. So now DPW is deciding that, oh, now we wanna follow the rules. Is that what that's?
We've
what I'm
been
hearing.
working with DPW in the past, and I'm glad they
Yeah, I'm
flagged
happy
it.
they're doing it now, but that's my question. Is
and-
that what it is?
It wasn't DPW that flagged, it was land management.
Bureau of
No,
Land
but he's
Management.
just telling me that they can't proceed because DPW is telling them that
It's
they
land
can't
management.
proceed.
It's land management.
Okay. Land management is telling you you can't proceed because,
They will not do the sign off on the building permit application until
Land
there's some
management.
land management,
There was
until there's some
some-
documentation showing that
Yeah, that one.
GPD can use that property.
so the existing buildings.
There's the
It's
existing
not-
building
it's-
right here.
Okay, okay. So we just know that it's there.
Yeah.
Okay, so if land management signed off on it before, where are those documents that land management signed off on it? Do you understand my hesitation? My hesitation is, of course I wanna help you, but I don't want to continue to be making the same mistakes of the past. You know, okay, yeah, we're pressured because they need to use this grant money, but let's please be wise about it. And let's please say, okay, how can we, if there's existing buildings there, land management, DPW, and everybody else signed up, signed on it. So we need to dig up those documents and they need to do that because I'm very hesitant to move forward, even if we're gonna lose $30 million, because then again, we're just saying, we're gonna make we're gonna make an exception this time because of the pressure. All of that's there, because they made an exception because of the pressure or whatever.
Would it work
Understand
for
what
them
I'm
to
saying?
do
How can we help them without,
I think the
Okay.
board has
what about,
given,
could they do a survey sketch to show that those things are there on that lot and attached to the
Well,
LOA?
that would be part of the requirement later on to do a retracement of the property itself to show,
As-built,
an as-built on the premises. And because right now, if you look at the area, there's a site, they're probably using just a little over the half acre, no, just a 1 acre, you're using a little over a half acre. So, I just want to include today that they're also requesting to get the whole acreage,
Yes.
okay,
Who's
for
the-
safety purposes, GPD.
Okay.
Now, as far as land management, there's no records. I went to land management, they dug as far as they can, even I myself, we have the same land web they use, we document search, I've done that. And DPW, there's no records of building permit back then, they only have records up to 2019 or 20 for building permits. So they cannot go back and says, retrieve the building
2019,
permit.
2019.
I covered my bases already.
Huh? No, you said, Oh, GPA? I know this is not a laughing matter, but what I see is that all the agencies are putting the pressure on this board to do something that's not right, and they know it. And so what's gonna happen is, oh, we're gonna grant you something, like our chairman said, the cart before the horse, and that's gonna make everything okay. So that's what I see. And, you know, we have been correcting the sins of the past since day one.
So-
And I'm telling you, we are just gonna, we are falling into the same trap as the prior boards, because they've been doing things, putting the cart before the horse, and things that they know that they shouldn't be doing.
This is why
So-
we're here now, ma'am.
Yes, so
doing
that's
this,
why we're here now, so I'm
and,
telling you,
just to let you know
why
that
don't
I
we
got a
do-
legal advice opinion from Norman Miller.
okay.
The one I just got through mentioning is about the options.
Does
Also,
he concur with this?
Yes, he concurred with grant of easement. That's what, that's
That
my
would've been
discussion with him.
helpful.
So,
So why
it's-
isn't that here? But you know what,
it
I
is
guess
there.
my,
Is it?
I guess
My report.
my hesitation is, we're gonna do a grant of easement, but that's just a grant of easement to do what, to get onto the property?
To, the grant of easement to allow them to do the, to build the generator housing.
Where? On a property that they don't have lease on?
Right, so the grant of, they would
You
only
see-
operate within
you
that
see
grant
what
of
I mean?
easement until such time
You
we
see
could.
what I mean?
yeah.
We're giving them a grant of easement to be on a property that they don't even have a lease on.
I see where you're coming
Yeah,
from.
no, so that's what I'm saying, is I'm sorry, GPD, but I don't know, we have to sit down.
Yeah.
You don't have to have a lease to be granted an easement. Either you get a commercial lease or a license
Okay,
or
I
a
know,
grant
but
of
a lease to
easement.
go where?
It's an
Where's the
instrument.
easement? The easement to go where?
To access the property.
Right.
Yeah, okay,
It's
to access
gonna-
the property that, do they have a lease on it? To access what
So-
property?
So there's three options. We can discuss, as Glenn mentioned at the beginning, the three options as also given by Attorney Miller is a commercial lease, a commercial license, or a grant of easement. And so the recommendation by us, CLTC staff and myself, is to grant the easement. It's not putting a cart before the horse, it's really just addressing what's already there, and allowing them just to build this
Generator
housing
house,
for, a generator.
So, yeah, but that's what I'm saying, they don't have a lease, so are they even paying? Are they paying for that property that they're on?
There's no lease, there's no license, there's no
okay.
right of entry.
So that's what I'm saying, you
Yeah.
want us to grant them the easement so that they can be on a property that belongs to CLTC and they're not paying a goddamn dime.
But,
Is that
okay,
true?
With all due respect,
I mean,
this
no.
is about communications for
Yes, so-
security and safety.
Okay, but that's, the thing is, you're putting us in the same position, no, it's, we need to find another way so that we're, 10 years from now, they're not looking at this board saying, oh, they just did the same as the other boards. That's not what this board is about.
This is why I mentioned, ma'am, that a grant of easement, if we can allow them, now, look at the MOA, we can look at that and mirror that, because in the MOA it says that they have 9 years, so
Why can't
that
we
would
just
end
draft the
on
lease right now?
2030.
Why can't we just draft the lease
By
right
that
now?
time, we should have, or
That's the
even maybe
problem.
next year, we can have already something, a lease or a license in place. But the meantime, right now, we need them
Not this-
to remain there and need what they need to do
license?
to build their generous shelter and also their right way for their electrical lines.
So maybe
That's
we
also
should
to
say
be
that.
included in later on. But that's just an avenue to try to mirror their MOA. I know it's not a legal government document,
Glenn?
but it's a way out.
Like I said earlier, we're not trying to harm GPD or their ability to perform and service the general public. But right now, based on circumstances, there is no lease, there is no license on that property. Granting a right-of-way to something that is not, it's unlawful, okay? It is unlawful because there is no lease or license.
We're not granting a right of way, we're granting an easement.
Even, that's the same.
How
No,
come
it's
it
two
says
different
here-
things.
How
It's
come
a
it
right of
says here
entry.
grant
Yeah.
of right of
It's a
way?
grant.
Why
It's a
does
gra-
that say there?
Anyhow, can I finish? I'm the chair. We want to try and resolve this, okay? And we want to be open-minded about it. Now, what's to prevent us from giving them a license or a lease to the property? They have nothing to support their occupation of the property.
If
They've
that's
been
the
there
will
for
of the
30
board, then
years.
that's the motion that you make.
Yeah.
If the will of the board is to do a license, and like we mentioned,
Okay,
there
so
are three
what
options.
what are the complexities for doing either or? Which is the most efficient?
Our recommendation is a grant of entry. Grant of entry? Is that the proper?
The grant of easement was what our attorney recommended, a grant of easement.
But the decision is the board's, and we're
Yeah.
bringing it to you, and there's three.
Yes, and
Can I
so-
make a quick comment, if you don't mind? You know, just like us, we have issues like this all the time as a, you know, as a law enforcement agency. And like they did, we would seek the advice of the Attorney General. And usually when the Attorney General gives us a recommendation, it's like 99.99, and the reason why is because the Attorney General is saying, Major Chargleff, we're recommending that you pursue these actions, or like, for example, dealing with a criminal case, right, and it's involving, let's just say, prominent people, or people that are literally connected to the government in many ways. So we would sit down with the Attorney General when it's dealing with, because I would venture to say this is kind of like a complex case. Because most of the time, you know, as an investigator, take the case, do the follow-up, make the necessary thing. Either we're gonna arrest them or refer them, right? Now, if it's kind of complex or we're still unsure, then we would seek the advice of legal counsel. In this case, it would be the Attorney General. He'll then recommend to us what he suggests we do. And usually when the Attorney General says, hey, you know, go with this decision, then it's. Now, in this case, your attorney or the COTC's attorney is recommending one of three, and you are, both of you are recommending the most efficient way to pursue it is the grant.
So maybe for
So
your
that's all I'm asking.
comfort, we could share with you the email we read from the Attorney General.
Yeah, I was gonna say, we don't have anything.
Right.
Do you need to be corrected?
Yeah.
There's nothing, there's no, I don't
Right.
see it in my packet. I
Right.
just
It's
asked
an email.
It's
Commissioner.
an email because it's not a public record. I can show you after later on.
Yeah, but you need to include it in the packet, that's
Yeah.
relevant information. How are we gonna make a decision? And you're telling us
Well-
that, I'm not,
If
okay, excuse me, I'm gonna remove you from the room.
you can, if you want
Yes,
to.
if you're gonna continue to be disrespectful to the board. You have a role here.
I am
and that
playing my role.
No, you're not.
Yes, I am.
Your role is to serve the board and I'm trying to get information so we can make the best decision possible. I'm letting you know, you're giving us information through your mouth, we have no paper. I don't know what the heck you're talking about, because that information has not been provided to us.
And please don't use that language,
Okay.
okay?
Use what language?
Heck.
Yeah, because
and
it's
earlier
not
when you
here.
said
It's not here.
goddamn earlier,
So
so we're breaking
there
that.
is an opinion, there is an opinion.
Okay, so we need
Uh,
to,
I'm gonna call for a 5-minute break so that everybody can cool down. But I tend to side with Commissioner Respicio. A grant of easement to where?
So we'll take the break.
There's no mechanism to support it. If they have property in there, yes, we can give them a grant of easement, but the property that they're occupying is not lawful.
So while we take the break, we'll provide you with the email.
Yes,
from the Attorney General.
okay, 5 minutes.
can you also
The time is 4:18 p.m.
Chairman, can we continue our discussion on old business item 5C, Guam Police Department, Lot 11, 1, Track 9, Block D? That's what we're
Yes.
on, right?
Yes.
Okay. So from what I understand, what GPD's request is to have a, let me get the right term, easement, grant of easement to the lot so they can construct a tower and generator shelters.
Generator shelter.
shelter.
There's
Okay.
already a tower.
The tower's there.
Okay, so to construct a generator shelter. However, the property that they're requesting an easement for, there is no current lease.
There is
So, I would like to make a motion that we grant GPD a temporary easement for 30 days,
Granted easement.
a temporary grant of easement for 30 days to reconvene at the next board meeting so that we can have a proper structure to have, so that GPD can have permanent access to the specific lot. Lawful
Access.
access to the specific lot.
Okay, a motion has been made. Can I get a second?
I second.
Okay. Motion has been made and second. We now go in for a vote. All those in favor say aye.
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 All opposed say nay. If there's no opposition, the motion passes.
Thank you for your time.
No, thank you for, thank you for your
There's one
support.
other item.
dinner.
Oh, yeah, the,
We're
we were
not-
talking that, the burrito.
Okay.
Which is a little bit different. There is a lease with Guam Power Authority.
Yes, lot 527 Marisu, there is a lease with GTA, and we have GPD there on that side too. They have their equipment there, and they requested to the board's permission to build and construct a generator and generator shelter on that premises. And the board, on the last board meeting, the board recommended that the letter come from GTA authorizing them to, requesting to have them build their equipment on their premises, and that was attached to your, the letters there in your package.
So it's a letter from GTA dated June 5th.
Okay.
So in this case, it's different because there's a lease in place.
And we have the correct lessee. We have the correct lessee
Okay.
approving the GPA's request. And we just come to the board to allow for GPD to access GPA property.
And build their
And to build, okay.
GTA.
GTA property, lease property, to build the generator and shelter.
I make a motion to grant GTA's request to allow GPD to build a concrete structure to house a new generator on lease lot 527 in Modesto.
I second the motion.
Okay, motion has been made and second. We now go in for a vote. All those in favor say aye.
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 All opposed say nay. Is there no opposition, the motion passes, we're open for discussion. If there's no discussion, thank you, gentlemen.
Thank you. Thank you all for your support.
Yes.
Oh, you can, this way.
Yeah, I'm just gonna, thank you again.
Thank you so much.
Yes, stay.
We'll get there, we'll get there.
Oh, I know we will.
Yeah.
It's just a matter of us coming together and
Yes.
getting it done. But again, appreciate your support. Thank you again. These are finding by my tenor code. Yes. Thank you.
The next item on the agenda is global.
And we have Dexter Tam.
The global recycling is just for an update, as requested by the chairman. So in your packet, there's a letter dated August 17th.
I'm sorry, before you begin, we don't have anybody from Global
No, ma'am.
represented.
Yes, but they were aware that they're in the agenda.
Okay.
Okay. So anyway, going back to the letter, so we sent a letter on August 17, 2026. It's on your packet. It's just following up on the request from the board from the February 4, 2026 meeting, and on the February 19, 2026 meeting, we requested for them to conduct the Phase 2 environmental assessment, and also Commissioner Respicia has also mentioned to them to provide the board a detailed report giving a planned preventive measure to mitigate current issues and prevent the recurrence in the future. The letter was delivered to them, and the response was via email that DRC has responded via email to inform our office that they are currently awaiting the contractor's schedule to perform the Phase 2 assessment. Once they get a schedule from the company, the contractor who will be performing the Phase 2 assessment, they will inform the board. But I would like to request from the board that we should set a timeline, because, we can send another letter if the chairman would allow through the director. That was my recommendation.
So, my question is, we set a timeline, and if they don't meet the timeline, what is the consequence?
Phase 2 environmental assessment is a very thorough process. So they have to do soil sampling, they dig the soil, they set it off island if it can be analyzed on Guam.
No, but the
Yes, sir.
timeline is to get them to act,
To act, yes, to
Yes.
schedule, to get a schedule, yes.
not to
For the proper,
include the amount of time required for the results.
yes, sir. So we can, I would recommend that we send them another letter to give us a schedule within, I guess, 30 days from today.
So what is the consequence? Let's say, because it seems like what they said to you responding is that,
Waiting.
oh, they're still waiting for the contractor. How do we even know that they called the contractor? How do we even know if there is
There's
a
a schedule, yes,
contractor?
ma'am.
Right, so, and your suggestion is to provide a timeline, which is a very good suggestion. So what if they don't meet the timeline? What will our consequence be? There has to be a consequence of them not meeting the timeline,
Yes.
because this has been going on for quite some time.
May I suggest
Yes,
that
what do you
at that
suggest?
point, we engage Guam EPA. We engage Guam EPA on.
We engage what?
Guam EPA. If they don't come in within the timeline on a response, a simple response could be them accepting some kind of proposal to a Phase 1, and
Yes.
then a timeline is established
Right.
on when your Phase 2 will be done.
Yeah.
But if no action is taken, my suggestion is that we engage Guam EPA at that time.
Okay, and then Guam EPA will be the one to either keep them open.
Give them pressure,
Yeah, okay,
But
so,
I don't believe we should give them 30 days. This has been ongoing. I think we should trim it down to 2 weeks.
okay, to give us a
And
timeline.
if they don't show us good faith that they contracted a environmental company to do the
Phase 2.
assessment, then they're in fault, they're in default. And it goes back to my opening remarks.
Illegal.
Yes, no?
Yes, so then, so that the consequence will be that we will then report to
Guam
EPA?
EPA.
EPA, and we go a step also further, because we
Okay.
don't know what's EPA's timeline. But we put them a notice also,
A notice for what?
possible eviction,
A notice of eviction.
yeah.
So my question is, if we evict, this is a general blanket question, if we evict a tenant and there's residue behind, the only way for us to get them to resolve that is a suit, is that correct?
Yes, ma'am.
Okay. Okay.
2 weeks.
So that would be a timeline for an appointment for the environmental assessment, for the timeline for the phase 2 environmental assessment, is that correct? That's
Yes,
what
ma'am.
you're gonna ask for?
Yes,
Okay.
because this is not the first time we've discussed global in a meeting, even prior to this board. And they're not very responsive.
Yeah,
Today is, just shows how true they are.
yeah.
They don't care.
Okay. So I would like to make a motion, Chairman, that based on the recommendation from the staff, that we respond to Global Recycling Center lack of, response to our request for a phase 2 environmental assessment, is to provide a 2-week timeline from Monday, starting from Monday, to provide us a timeline of when the assessment will be and the consequence, and I think that it should be clearly stated in the letter, that if we don't get any response from them, that,
Eviction notice before coming.
yeah, eviction notice will be forthcoming, and also EPA, I don't know what you call it. We will call EPA on them,
Yes, involvement.
for lack of a better term, will involve EPA.
We have a motion on the floor. Can I get a second?
I second.
We have a motion and a second. We now go in for a vote. All those in favor say aye.
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 All opposed say nay. Since there no opposition, the motion passes.
All right, so we'll prepare the letter.
Okay.
Okay, the last item, I'm sorry, go ahead, ma'am.
No, you-
Okay, the last item on the agenda, item letter G, is the draft bill for the CLTC to hire its attorney.
We did request from the vice chairman, and he did provide the draft. So that's in front of you and for consideration.
Okay, ma'am, boy.
Since this is a draft, can we include the language that says that they will earmark money for this?
Oh, to add?
Yeah,
For the legislature to.
yeah, to earmark money.
So the other question I have is, according to this bill, draft bill, is that the attorney shall be, the commission will employ the attorney, but the attorney shall be appointed by the Attorney General as an Assistant Attorney General. So does this mean that whoever we hire will be employed by the Attorney General? Is that what this verbiage is saying?
Under supervision.
Because it also says the attorney shall serve under the general supervision of the Attorney General and may be removed for cause. So it seems that we're gonna hire an attorney that's going to be under the Attorney General. But is that how, for example, I know like the airport has an outside attorney, is that how it's structured?
No.
Okay, so then why are we doing something different, is my
This is
question.
the proposal from the legislature,
Okay.
and it's for us to make recommendations.
So I would like to have an attorney like all the other agencies do, like the airport. I know they have a private attorney. I don't know if that private attorney is serves under the general supervision of the Attorney General. I don't know if they're considered an Assistant Attorney General. So I'm not sure what the difference would be. We are also an agency of the government of Guam. So I think that the, how do you say,
We can
the
perhaps mirror like.
kind of attorney, yeah, I wanna
Yeah.
mirror it like other agencies. Why should we be different?
I think we should mirror, let's look at,
Is DOA's attorney under the same type of stipulation?
that's what we have to look at
Yeah.
is the line agencies, right? The apples to
Are we
apples.
considered a line agency?
We
Yes.
consider
Okay.
the line. So we'll look at, there are attorneys within line agencies and we'll look at how that was,
Worded.
Set up.
yeah, how that came about.
So that's my, I guess, my comment is, you know, not to accept this at the moment, but to see how we can be, you know, mirror the other agencies. I think we're just as important.
There's a few, there's like Rev and Tax, that's a line agency
Yeah.
who has their own legal counsel.
Guam EPA.
Oh,
And
see,
Guam
Guam
EPA,
EPA, yeah, okay. So, make
Okay.
a motion to table? So I'd like to make a motion to table the draft bill for CLTC to hire its attorney until the staff can provide more information with regard to the general hiring of other line agencies.
Motion has been made, can I get a second, please?
I second.
Motion has been made and second, we go in for a vote now. All those in favor say aye.
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 All opposed say nay. Since there's no opposition, the motion passes.
Thank you.
Mr. Chair, yeah, I think the next item on the agenda is item 7, the comments, and we do have somebody here to speak to the board.
Yes.
Okay. Okay, go ahead. Oh, separate, okay. Do you wanna go?
Let's see who's on, sorry, let's see who's on your
No, no, you were not.
Okay.
Sorry, I'm sorry.
If anybody needs some.
Do you want a
Wait, let me continue.
We ignore them. We ignore them,
Oh, I thought I did it.
No. Sign here?
Yes, please.
Oh, you sign first.
Mine's short.
Again.
Mine are short.
Mine's really short. I'm gonna give you these two. It's a written statement.
Oh, thank you.
It's written, I prepared it.
Okay.
I'm sorry.
Thank you, thank you.
It's a written statement. There you go. I try to time it under 3 minutes.
Okay.
I'll
Here,
try.
so, sign.
I'll try and finish it in 3 minutes.
Sure, sign.
So, Mr. Chair, we have before us, in our public comments, Katrina Regis, who prepared her statement, and I guess we should allow her to read her statement first?
Just, if you don't mind, just to provide clarification, Ms. Katrina Regis is the named beneficiary for Mr. Ilaria S. Senecas?
Is his name here?
Valeria? Yeah.
No, because it's on public comment.
Okay.
Or I don't know
No,
if
but
it's
is
on
it
her.
in here, in her
No.
statement? No.
I don't-
Okay.
I didn't. I was trying to keep it as, I was trying to streamline this as much as possible. So I wanted to just put in just the pertinent things for the board. First of all, I'd like to say happy day and good afternoon, Chairman Garrido and Board of Commissioners. My name is Katrina Nicholas Regis. I am the successor to my parents' 6-acre agricultural lease. I respectfully ask for your assistance regarding an urgent matter affecting my farm and $76,000 in approved USDA Natural Resource Conservation Service funding for agricultural improvement. This funding directly fulfills the core mandate of the trust. My parents' agricultural lease was issued in April 2012.
And since my parents' passing, I have continuously farmed and cultivated the leased property for approximately 10 years. I have maintained my status as a bona fide farmer with the Guam Department of Agriculture and completed the core pesticide training through the Guam Environmental Protection Agency. The 76,000 USDA NRCS funding will allow me to make significant agricultural improvements, including high tunnels and irrigation infrastructure. These improvements are especially important because my farm has suffered substantial damage from recent typhoons. The funding represents an opportunity to rebuild and strengthen an existing productive agricultural operation. My farm also serves a purpose beyond production. I have collaborated with the University of Guam, including professors and students who have participated in hands-on learning at the farm, such as identifying pests and learning proper tree trimming practices for healthier growth. The COTC board approved my successorship in December 2025, and I am now working through the remaining approval process. I understand that because the agricultural lease exceeds 2 acres, which requires legislative approval. I am not here today to discuss that process. I am respectfully requesting the assistance in preventing the delay of jeopardizing the federal funding that has already been approved for my farm. I respectfully ask the Commission to consider whether there is any lawful way to facilitate or support the land concurrence process while the legislative approval is being completed so that the $76,000 in approved federal funding is not lost because of an administrative timing issue. My goal is simple: to continue my parents' agricultural legacy, maintain productive use of CHamoru Land Trust agricultural land, and use these federal resources to contribute to Guam's agricultural community. Thank you for your time, consideration, and assistance.
You know, this is the open public comment section, and we cannot make any formal decisions because you came in under public comment.
Right.
But what we can do is schedule you on a regular board meeting.
And thank you. The reason why I'm bringing this up is because I came here a couple of weeks ago asking for, I brought the USDA contract with me, and then it got all mixed up with this 2-acre thing, right? Because the land actually belongs to CHamoru Land Trust. And all USDA wanted to do was just address the fact that the land belongs to CHamoru Land Trust, and they just wanted concurrence so I can continue with this grant. And what they have done was extended me, and I said they're still trying to decide. I don't know what they're going to do because they were finding out, I was finding out that my package is down at the legislature, and I called the legislature up. They says, we can't find that package. What date was it? So CHamoru Land Trust told me it was transmitted down to the legislature March 30th of 2026. And so the legislature, you know, the person I spoke to in that office said, we still can't find it. So I'm kind of like stuck between, all right, one office says they submitted, the other office says we've never received it. And the clock is ticking on this grant, and USDA has already given me an extension. And we've been sitting on this for 2 weeks. And, you know, we're talking about sizable amount, and this is CHamoru Land Trust land, and the lease is legitimate. I mean, I like to think it is, and I am the approved successorship.
So, can I just ask staffer Joey Cruz now? The property, so we're in the process of transitioning the property to Miss Catherine Regis, is that correct? Is that where we're at? And so that's what she's talking about with regard to the packet at the legislature, just to get that approval to.
Because it
Because
exceeds
it's 2
the
acres, correct. So that's the reason, so.
If I may,
Yeah.
just
What is
chiming on this
the best way to
conversation.
facilitate this?
So I've been tasked now, because I did visit Miss Katrina Regis' farm 2 days ago. I've been tasked now to oversee the compliance section of the Chamorro Land Trust Commission. Mr. Senecas' lease, which is her father, was given outside of the first come, first serve, which created it to be a clouded lease.
Okay.
Today, instead of terminating the lease because of that infraction, the legislature passed 37-131, which requires us to go out and do compliance inspections, which we already did. We're just putting everything together. We're putting our reports together and all that other great stuff. However, the law only allows a successor to maintain 2 acres. If she would like the 4, she can, but she has to commercially lease it. That's what the law says on how to address leases with a cloud. In regards to the NRCS grant money, to my understanding, after a review of Glenn, of where the improvement will go, it exceeds 2 acres. So we can't just approve that knowingly that if she doesn't agree to commercially lease the 4, she's only gonna get 2. And then there's other things that are occurring through our review. I know she's just here to request for, but just to give you some idea of what we're doing, we've already GPS, they plotted it, we're gonna compare it with a map. There are some other issues of concern that are non-compliance, like traversing to an easement that's not an easement. I do understand that you were given authorization, water easement, but however, that doesn't comply with the agreement, right?
There wasn't a water easement, she just gave me easement to get into the farm because,
This document says otherwise. It's recorded, right? So, so we're going through this whole thing, but nonetheless, today, unless Ms. Regis agrees to commercially lease the additional 4, when we complete this whole process, we're only gonna present to the board for 2 acres, because that's what the law says that allows to give Ms. Regis, instead of terminating it, right, because it's a clouded lease.
So have you discussed her option to lease it commercially?
We did, we even provided a copy of Public Law 37-131 when we visited her.
Are you agreeable to, if that's the only way to move forward, are you agreeable to do commercially?
that would be to my disadvantage if I do it commercially. My father had this is an agricultural lease. Now, if it's under 75A 10A, capital A 107A, that would fall under commercial agriculture. That is where it's 0.5 to 20 acres. If I fall under that category, yes, I would agree to it, because under that section, it says commercial agriculture with 0.5 up to 20 acres.
Right.
I would like to fall under that category, because it's under 6 acres.
So it brings us.
Oh, because 0.5 up to 20, but it's 6 acres, so it does fall in that category.
Yes, and
Okay.
it is labeled under that section, commercial agriculture.
It refers back again to the issue of non-compliance.
Right.
Right, which is 37-131. If CLTC did it correctly to begin with, you wouldn't have got a 6-acre property or your dad. He would have just had a half acre because it's subsistence farming. Anything greater would have been considered commercial, which is a whole different agreement.
But this is not a subsistence farming. The lease that we actually got says agricultural lease,
Understood.
and it was there for profit. It's for production, and that's what that term says under that 75A 107A. It says that there is for 0.5 up to 20 acres, and it's labeled commercial lease, and it's still for $1 a year. Whereas we did the commercial lease, that would be different. And it would be to my disadvantage, and it won't be according to the lease that my dad had signed, where it was $1 a year, and my dad had already paid $50 into it already.
To no fault of your dad's or yourselves,
Yeah.
like I said, if Chamorro Land Trust issued it in the manner that it was supposed to be, just as you cited in the act, if it was greater than half an acre, it's considered commercial. There's other parts in the act that says what has to be done if it's for commercial leasing. And it won't be for 99, it will only be for 21 years. So to remedy the situation, which is not, like again, no fault to your dads or yourself, and instead of terminating it, the legislature passed 37-131, which will at least allow you to maintain 2 for subsistence without increasing the rent. If you want to maintain the other 4, that again is a different type of lease, which would be a commercial lease, which of course the rates will be different.
Right, but why couldn't I just use the 75A107A? Because that goes from 0.5 up to 20, and that's not a subsistence farming. Subsistence farming is less than half an acre. But when the lease was given to my dad, it fell under that category of 0.5 up to 20, and that is considered commercial agriculture. And I have fulfilled that 2/3 of that lease.
Understood.
And also, the farm has always been productive even since the passing of my father.
Again, it just speaks to the incorrect process that was executed to begin with on our
So,
part.
I guess that's why I'm trying to understand why, you're applying 37-131, but why are we veering away from that when there's a 75A107A where I fall under that 0.5 up to 20 acres?
So is it my understanding that under the commercial farming, which he's describing, it's not $1, the lease will
It's
change?
not
So
supposed to be.
basically, what I understand, please correct me if I'm wrong, is there was a lease issued not in the correct manner. It wasn't an error lease, it's just the manner in which it was issued was incorrect. Now that your father has passed away, correct, and you're gonna take over the lease, now we have to make a correction because the lease will have a change of name, and when we're changing the name, we have to change the lease to be in compliant. Just like you heard that whole scenario with GPD, where we have to change things to make it compliant. So in order to make it compliant, we can continue that lease under commercial, but it won't be for $1. It'll be for whatever the legally stated amount is. So you're still gonna get your 6 acres, you're still gonna get commercial lease. The only thing that'll change is the amount that you'll be paying.
So that section that I quoted then is null and void,
No,
did
it's
they
not that it's
reverse
null and
that?
void. It says it's not supposed, they only charged you $1 per year, and they weren't supposed to charge you $1 per year. Basically, you got away with 21 years of $1.
So, just to add to it, when your dad's lease was issued, it was issued under the Chapter 75.
14 years, actually
Yeah,
it's
or
14 years.
yeah,
The
so.
It was issued under the Chapter 75, which is almost a duplicate of Chapter 75A. The only reason why there's a Chapter 75A is because we got a civil suit, and they expanded the eligibility beneficiary qualification. So even in the Chapter 75, it says anything below half an acre subsistence, anything greater is commercial. However, again, to no fault of your own or your father's, and to ensure that we don't displace you, the legislature passed, or the governor enacted 37-131, which will allow you to maintain the 2. But if you would like to maintain the entire property, the 4 acres has to be
So it would be
commercial.
at commercial rates, is basically. So the difference, the only difference would be at the commercial rates, because there's a new law that changed it. If it changes owners, then it's, so then it changes. Is there a significant difference in the lease
We
amount?
don't know because of appraisals that would have to be done.
Oh, I see.
But yes, because $1
Yeah.
there'll be a significant.
Even if I was beneficiary before the law was passed, because my mom had given that to me in 2020, the law passed in 2024.
You didn't
So-
succeed it yet, the lease. So even if the dates, the issue at hand is that your dad's lease is a clouded lease. So instead of terminating it based on the procedural error that we did, to maintain at least your lease and not displace you or your dad at that time if he was still alive, again, the law was passed, you can maintain 2, and if you wanted to
Can you explain what is the clouded lease? Because I'm sure everybody who received a lease thought they were getting a good lease.
So there's about 2,800 plus clouded lessees. You're not the only one. It's either they gave your dad his lease prior to his date and time, which is from my quick review, that's the case. That's one. Two is they gave him over the acreage size. Meaning, like you mentioned and you cited, anything half acre, subsistence, anything greater is commercial. So that's the clouded, that's what's clouded your dad's lease.
So this lease where it says it's $1 a year,
It's clouded.
it's clouded. I
Yeah.
mean, I understand, yeah.
Yeah.
Like I said, there's 2,800 plus current lessees today that are in your situation. Like I mentioned to you too at your farm, because you brought up some other lessees, we're putting a schedule together, and it's not only gonna apply to you. The only reason why that your file is here today on top of the desk, trying to not expedite, but to go through it thoroughly, is because you came in, we had inquiries from senators' offices, so we're working on it diligently, but however, our report is not done. As soon as our report is done, we'll call you in to meet with you and explain everything.
So, can I just ask?
How much of that area are you actually farming?
I am farming all of field 5, all of field 6. I am farming over 2/3 of it that I've got orchards in. 'Cause
They're
I'm-
long-term crops,
Yeah,
not
yeah,
cash
this
crops.
is a fruit tree, this is a fruit tree farm that I've converted from cash crop to now all fruit trees.
Yeah.
And so I wanted to use all 6 acres all for fruit trees, but, you know, I know commercial leases are sky high, I know, I mean, but I'm not putting in a warehouse, and I'm not putting in any commercial buildings, you know, or hotels, and so do I get that same kind of rate that you're gonna charge these hotels and these commercial buildings? What
It'll
kind
be
of?
based on the
It's first an
appraisal,
appraisal,
so
yeah.
if you don't have those type of structures, obviously the appraisal won't be that high, right? So the appraisal is based on what's on the property, so it would be based on the appraisal. So, back to her request, because we want, the funds have already been approved. We wanna assist her so that she can avail of these funds. How can we facilitate this process, or do we give her like a temporary something so that she can get the funds and then it'll get approved by the legislature? What is the?
The document really, the land concurrence document is saying that the owner, CLTC, acknowledges that and gives her full rights and use of the property. However, that's kind of a gray area because that speaks to 6, not 2.
But she wants 6.
Yeah.
Well, I spoke, if I may interject
Yes.
here, I spoke with CTLC, in fact, I have it in writing too on the text, and I said, in the event that I am restricted to 2 acres, can I move all this money into 2 acres? And she said, absolutely yes. We can do that.
We
We
spoke
can.
to the NRCS, cause
Yes.
that's what, they're the ones giving you the money.
Yes,
Okay.
and so she says, yes, we can do it, and she says, but you gotta make sure that you know where that
Two's
area
gonna be.
is. And so I would like to, so what I would like to do, if I may propose, is I have the NRCS contract for either the administrative director to sign or the board to sign, whoever wants to sign it, and then we can note it on the bottom that it is still pending legislative review or approval, right? And then I'd like to identify where the 2 acres is at, to concentrate where I wanna put the high tunnels and all the irrigation system, because there's gonna be infrastructure going in.
And that-
But I like to identify.
But then that needs to be subdivided, right?
Yeah, but
Surveyed.
there's
Yeah.
other concerns that may be, because
But I might want the 4 acres, because it's gonna be,
You
because
have to decide.
I wanna get, you know, I wanna get the, I wanna see what the appraisal value would be on, but if I'm gonna be given the 2 acres,
I think one of the things is that, to my understanding, NRCS has already mapped out or did something, plotted something within her leased property, which covers more than 2 acres. Another thing is, I don't think a simple message on the
Yeah.
concurrence would suffice, at least in terms of liability, right?
Yeah.
And another thing is, if there's no definite answer, whether she wants to maintain the forward commercial or not, because once we're done here, and I don't know if you've already qualified as an eligible beneficiary.
Yes, I did, I was approved in December in December 18, 2025.
Okay, so
I
you-
am the approved successorship.
No, I mean your
Oh,
eligibility
eligibility.
for the program, but if you
So-
did already.
Oh, yes, I did, because my parents' property, my mom's property from Sumai was taken. I went through this with Glenn already, and I provided a
Okay.
family history.
I didn't like go through it like individually, but all I'm saying is that as soon as it's been concluded, our report has been done, the next process is you've qualified already, it's time to present to the board to issue a new lease. If at that time you haven't made up your mind, your case is still gonna linger. And
can
we
I
have
just-
1 year to resolve all of this.
Can I just bring up a risk in signing this document, whether it's myself or you, the board? There may be a liability to Chamorro Land Trust if we authorize the installation of this equipment and at some time, the property is reduced and this equipment is not on the lot that,
Correct, yeah.
you know, we may have to
Pay.
reimburse somebody for
Who
something.
knows, right?
But wouldn't I, as the current, well, I'm just a successor right now, but because I'm one that's utilizing the land, you know, and cultivating it, don't I get to choose where the 2 acres is going to be? Because right now I have a structure on it, which is an accessory structure, which is allowable
It's
by.
gonna consume part of your 2 acres.
Right, and that's fine, because wherever the structure is, I will work within the 2 acres of that structure. So if I could be the one to choose where the 2 acres is
I don't know how
at,
that works.
because
Does
it'd
she
be
get to
right
choose?
over by
Without
So just so we all have a idea, right?
a sketch, it's kind of.
So we have like an aerial. The structure she's talking about is here.
Yeah.
So, you know, our person here is also gonna have to sit down and look at the highest and best way to design this, if she
Yeah.
takes up 2.
To
And currently,
configure the boundaries.
if we turn to this document, this is the easement, not the easement that's going through here. The actual easement is this way. So logically, we're gonna have to say, okay, Miss Regis, your lot's gonna have to be a rectangle this way, because the easement comes in like this. You cannot use this easement because it runs straight through 2 lots,
Do I
which
get
is your
to
neighbors.
Do I get to sit down with that person? Cause I know that very well where I know where the rights of way is, where the easement is at, because
We
I
have a
have,
sophisticated AutoCAD or GIS system here. Understood, you've been there for a long time, but what matters is what's been recorded already and severed out as an easement. If, like I mentioned, where this picture's at, this is how we entered your place. However, this traverses over 2 lots. That's not gonna be the easement, that's not gonna be recommended because you're displacing the 2 lessees beside you. The normal easement is to come up this way and then hang a left. And then where your house or your structure is situated, you know, I'm not the one who's gonna design it, but I would think that they would give you and not landlock you. So
Oh,
put
yeah.
you closer to the easement.
I am close to the easement where that structure is at. I
Understood.
mean, I did get authorization from those 2 land, owners,
Yeah.
cause I asked before I put the road in, can I put my road here?
So the only,
And so they gave me permission, they said, sure, go ahead, and so
Yeah.
what I did was I planted on
the coconut trees.
their coconuts, I says, can I plant on your you know, to make it as a driveway, she says, yeah, go ahead and plant the coconuts.
So when is the deadline for your funding?
Saturday.
Well, actually, it was 2 weeks ago, but they extended it for me, and they said if you can get this thing done this week. And so right now USDA is on island attending the Pacific Region meeting over at the Hyatt with, I don't know if you're familiar with J.B. Martin and Jay Duranilla from USDA, and then Glenn, Takai is talking with them to see what they can do.
So,
What-
given the urgency, how do we help her? Because there's also, there's decisions on your part that you haven't made, whether you want 2 or 4. We need to know that so that we can sign the document and we can have the proper lot number.
I would think that initially she would have to make that decision, do you
Yeah.
want 2 or 4 or not? And then another thing is that we're gonna have to go out there and go with her, and she's going to decide just an area of where the 2 would be. Then we have to GPS it, bring it back, have our planner 2, Mr. Torres, go out there and see if it's feasible or not. I don't know, but we can reach out to Mr. J from NRCS and see if there's a possibility for an extension. I don't know, but we can ask. But I just wanted to speak on your comment about the easement that was granted to you. I'm gonna pull their files to review whether there's actually documented easement given to you. That's one. 2 is they should have came to CLTC to request for authorization to grant such a request. Because too many times we see constituents allow things to happen, they come in here and then they expect us to correct the infighting between lessees. But I just want you to know that the easement that was documented, that was recorded and approved by CLTC is a 5-foot water easement. I don't know if that's the easement you're speaking about, but that's not a right-of-way easement. We will put that in our report to remove the fence because it's obstructing us from doing our jobs for your neighbors. But nonetheless, I think we can reach out to Mr. J and ask him if there's a possibility for an extension. How long, I'm not sure, but this is all contingent on how Ms. Regis would want to decide or how soon she
So-
can decide.
This is the map, the survey map that was submitted to you guys. This is from NRCS. So this is the shape of the property. This is where the building is. This is the easement right here that was actually assigned to the farm. And they got that easement. The one that's coming down the middle, yes, it belongs to these 2 landowners, which they gave me permission. Now, I don't know whether they went through the process, but I spoke with her. But this one right here is the easement going, and this is where the orchards are at, right here and back here. But this building here is what I'm talking about, which is right close to the easement.
So that map
This,
is based on a Google map. We don't know their shape files or their aerial imagery. Our map is based on maps that have been recorded. So there may be a 20-foot difference.
Right.
However, your easement is here and it's mapped out, line delineated and everything. So
like to compare
Google
that to
map may
this.
not be as accurate as what we have because these are actual maps that have been plotted into the system and
cause this
all
is
that
what,
other-
this is what NRCS
Understood.
did, this is what NRCS gave me, and so I've been working within these maps. I
Understood.
try not to go into any of others' property, so I just like use
Understood.
this map, but I know where the easement is, and if I'm allowed to choose the 2 acres, of course, I would take the one closest to the easement. I mean,
Give her
whether
a
give or
copy of
take
that
20,
So she knows the
Yeah.
exact,
We'll give you a copy.
so she knows where the proper easements are.
Yeah, that's fine, we can give you a copy.
well, at least the rights of way to get
Yeah.
into the property, I know where that is.
That's
but-
the Chamorro way of,
But
but,
I'll let you know, I do want all 6 acres. I
so,
do, I want
think
all 6
this
acres.
is something that,
or-
we've been working with Ms. Regis, and we will continue to work, and I think that, as mentioned, it's something that she needs to decide, right? So that we know what direction to go, so I'm not sure that there's anything that the board can
We can't
do
act on
today,
it.
this time,
yeah, yeah.
We can't act on it
Yeah.
because you came in public.
Yeah, I know, but what I'm asking is just to sign a concurrence document, it belongs to CTLC.
but the
you
concurrence is
know,
speaking to 6 acres.
But if I can move that, cause I spoke with that person and I said, can you move it to 2 acres, which I already know where the 2 acres is going to be, if I'm going to decide right now, I know where the 2 acres is at, and then I can later on work on the 4 acres, cause I would have to get an appraisal and everything and decide from there, but as of now, I still want all 6 acres. But if I'm gonna be limited to 2 acres, the person I was working with at NRCS says, yes, we can take it and make it comprehensive where I want it into 2 acres.
So there's still many issues that need to be resolved before we can get to that point.
Yeah.
If he can share his aerial imagery of where he plotted where the two's gonna be, so that we have an understanding when our planner here starts to design the subdivision of it, if you should choose not to.
I have it here,
Okay.
and it's 3 point some acres.
Yeah, so if he shrunk it down to 2, if he can share us with the updated, again, it's not saying that CLTC is saying you can't have 6. You could have 6, you just have to choose to maintain the 2 and commercially lease the 4. Again, it's the hand we're dealt with, and this is our direction how to deal with clouded leases.
So I think moving forward.
Can I just say something? My name is Angelita Mindiola. I think if we could, like what he said, if we could get NRCS or USDA can extend that timeline.
And then you guys can work it out. You can work with the staff to work out which direction you're gonna go so that we can
I
actually.
believe it's possible, because we had a constituent who waited a couple of months, because of, for whatever the reason was, but there was quite a few extensions granted. That's why I said we could ask if it's possible, or you can ask.
And if it's not
him.
approved, if the extension is not, she's gonna lose out. That's a lot of money.
I understand, however, it's our job internally to make sure that we look out for the liability of the commission, and we
I know,
don't.
but can we just say that it's subject to the 2 acres? You know, if we put that down on the, when we're at the bottom of your signature, that it'll be subject to the 2 acres?
Can I give you any assurances in the public comments?
No, like,
If you want, maybe you can consider writing a letter stating what you wanna do, get it notarized and submitted, and then we'll go through it. And at that time, if already it's coming to the next board meeting and you do get an extension, then at least you'll be on the agenda. Our objective here is to complete the compliance inspection that was conducted the day before yesterday, so that you can avail of a new good lease that's not clouded by law. And the next time you see us is probably just to pay the 99, or if you already did, or, you know.
Joey, I mean, I've been communicating NRCS for the longest time, and for the past week and 2 weeks with Jay, and this is their standing is that if they don't have a lease, and we can't, let's say for 2 acres or 5 acres, and we can't concur that they have a lease, they will not grant that the funding. They have to have a lease.
Okay.
That's the purpose for the concurrence.
Understood.
So even if you say there's 2 or 3 acres, they have to have a lease that hand.
so my successorship is not a lease?
We're-
I'm not getting this lease?
We're working towards getting you your lease.
I know, but isn't that already an existing lease? I'm already a successorship. The lease actually exists.
Understood, but it
And
hasn't
being
conveyed
you-
yet, so.
But being approved as a
So it's a
successor.
clouded lease and we want to avoid creating another clouded lease, which is why we're taking all the steps necessary. So once the lease is issued to you, we can't question whether 6 acres or 4 acres or 2 acres was legally leased to you. So we're really just trying to avoid, as Commissioner Vestigia said from the beginning, continuing things that were done in the past that shouldn't have probably been done.
And it's gonna be now to my own detriment. It's not really helping the issue.
But-
This law is actually now to my detriment. It's not helping me at all.
I would think that you want, when we
And
issue
I'm going
your
now from
lease,
6
for
acres
it to
down to
be
2.
bulletproof and not questionable, right?
So basically, you're a successor to a lease. You don't have a lease, so.
But the lease still
Yeah.
exists.
But so in order to get you on the lease, in order to get you a lease, we have to create a new lease with your name on it. You're the successor, like, just think of it like if you go to a bank and you have a bank account and it's the same, you know, you're the beneficiary. So when the primary person passes away, in order for you to take the funds, you can take the funds, but you have to open a new account under your name, right? You can't continue that account under the primary person's name. So it's the same thing with that lease. You have a lease with your husband, was it your father? So now he, has expired. So now there has to be a new lease under your name. You cannot continue a lease under a person that's expired.
So, if I may,
That lease, they're gonna use that property for your new lease.
So that's what I'm saying, there is a lease.
There's a
There
lease
is
in
a
your
lease.
dad's name.
I know,
Yes.
there is a lease, it's in my dad's name, and I'm just trying to find a way how to still not lose that money, cause there is a lease. There is an existing lease, so,
But it's not
and
under your name. And
I understand
yeah,
that,
no, but that's what
then
NRCS is requesting, is to say that it's under your name, right?
they're asking if there's a lease.
So
and there
just show
is a
them the lease, you have a lease and you're the
We
successor.
discussed this before, when you first applied for NRCS. And we went through the training, you went there at UAG, and the question was asked, if I'm successor or I don't have a lease, can I apply for NRCS? The answer is no. You have to be the name
On the lease.
on the lease.
But that's not true, you know why? They just awarded me $1,400 when I needed it for my fruit trees.
So that's what I'm
NRCS
saying,
did
if you were able to use that document to attain the $1,400, use the same document for your $76,000 while the CLTC is crafting a new lease under your name.
I'll ask them, I mean, I don't know, but they had already given me
I think-
grants.
You see what
I
I'm
even
saying?
I
got
think,
grants from
if
the,
it's possible, we should set up a meeting with Mr. J, yourself, and come in and let's discuss it. But in the meantime, we're compiling our report, we're following the direction to get you a new lease. The only thing that's gonna be required for you, at least at this time, is whether you're gonna maintain the 6, keep the 2, pay for the 4 acres, pay commercial rates, or you just want the 2. So that there's no confusion.
so because it's a clouded lease, not my fault, my father's fault, actually the government is penalizing me, is actually what's 37-131 is. It's not smoothing it over, because that was the whole intent of that law, was to smooth it
The law's
for the
intent was
land lease, but it's not smoothing it over, it's actually to my detrimental, because it's going from a 6 to a 2, and I don't want, to have it a commercial lease, there's a commercial agriculture that falls under the 75A107A, but you guys are saying, oh no, it has to be 75A126.
Let me correct you. What I said was, we issued your dad's lease based on the 75, not the 75A. However, when the lease was issued to your dad, it was done incorrectly, because we didn't issue it to your dad based on his date and time. Your dad received this lease before 3,000 people received their lease, who was before him in line. So to prevent the termination of 2,800 some leases, a bill was created, passed into law, so that you can maintain at the very least 2 acres if you were given above. So
If I may, if I understand this correctly, what my dad had told me, that land was not CTLC land. That land came from Department of Agriculture. And that's the only reason why Agriculture transferred it to CTLC, that same amount, and that's the land my dad got, because my dad was getting it under Department of Agriculture.
But now we use CLTC's rules and regs to apply, because I'm just gonna assume that Department of Ag lease expired.
probably was
Yeah.
expired already.
Probably expired.
So, I understand where you're coming from. However, the CLTC rules will grandfather you into the program because you were considered a preoccupier if you meet the eligibility beneficiary requirements.
I do.
However, it doesn't guarantee you the same acreage. That's the only difference. You may have had 6 acres at the Department of Ag, you come here today. If you want 6, that's fine. just pay commercial rates. If not, then you go to the subsistence area side.
I don't fall under that one program where the land was taken from my parents.
You just said that
It just qualifies you.
for the program,
It qualifies.
yeah.
So-
But again, if it's okay, we'll contact Mr. J, we'll reach out to you too, we'll set up a meeting and let's discuss it. In the meantime, you can decide whether you wanna keep the 2 and not pay commercial rates, or you wanna keep the 6, 2 non-commercial rates and the 4 commercial rates. However, again, there's gonna require some work to be done on our part, because we have to ensure that if you decide to keep the 2, we don't landlock or displace anybody that's next to you.
So I think that you can make an appointment right after we adjourn so that you can start working on it right away.
We'll
And
reach
then,
out to Jay
yeah,
also.
As, what he mentioned is he'll call NCRS, right? NCRS to
try
to help you with the extension. So right now, we're trying to find ways to help you as the best we can, because of course, we don't want you to lose your lease either. You know, you've been there for a long time, you've already developed the property. So it's just a matter of correcting the paperwork and getting it right.
I'll sit down and I'll see,
Yeah.
because I really don't wanna convert it. I really wanna, well, we'll see,
I
I
think
mean,
we put the
not,
options before you, and maybe you just need some time to figure out what.
well, that's my option,
Yeah.
either commercial lease or commercial agriculture. I would choose the commercial agriculture over commercial lease.
I think
If I had that choice, I like commercial agriculture rather than the commercial lease. And that one falls under 0.52,
So
up
let's
to
have
20
this
acres.
discussion at
Okay.
the meeting that the
Okay.
commissioners recommended.
Okay, all right, I will,
Thank you for coming in.
So what we'll do is we'll contact Jay, find out his available time, we'll get several dates, and then we'll call you so that we can.
And I'm sure, we will definitely work with you to make sure you maintain what you have.
If USDA is willing to accept the lease that you're holding in your hand, there's no need for you to come before us.
The land concurrence is what she needs.
Yeah.
That's the only thing to release the grant.
The land concurrence comes from you guys.
It just literally says that she has full control and rights to the property.
Oh,
However, there's a cloud, right?
right,
So,
that's why we can't, I see, we can't approve that.
yeah.
Then how did she get the 1,400?
Exactly.
That's why I
got
said,
That was
if
my
you got the
passion.
1,400, then you
Yeah,
should go ahead and
maybe-
use the same
maybe-
process to get the
They never gave me this
Maybe that
form for you
program's not
guys
as
to
strict.
sign.
Yeah,
I
that's a
never-
different program.
Okay.
Okay.
Thank you very
much,
It was under
thank you.
equip, both are under equip.
Okay, now you have to push.
Yes, yeah. We have to adjourn, sir?
You have to make a motion.
Oh, I make a motion to adjourn.
Oh, we have one more,
Oh.
I'm so sorry.
What?
One more, public
Oh.
comments.
Hi.
Thankfully, whatever was discussed here was pretty much, yes, so I don't have to introduce, right? Question.
So is it something that we can schedule to discuss with us?
It's real quick, and then, of course, it might,
But is it
but
some,
I'm Doris Sanchez Iriarte. This is regarding the notice to remediate.
okay,
So maybe just in general, I just wanted to present to you, I went to the senator's offices, but of course I know the protocol is to come here first and request the approval, of course, of the board with the staff providing everything needed to make a resolution, right? To amend or make a law, right? So the notice to remediate, they've only given 1 year, right, for that, and I'm not sure the history of why and all that, the discussion with the legislature, or what the intention was when Senator Terlaje presented it, right, as a bill. I'm not sure what the reason was that they limited it to 1 year.
okay.
So, I'm just wondering, I'm sure the staff and the board, right, will have all the information to decide how many years, if hopefully that you will agree with me that if we could extend that.
If it's not by law, we can't do that.
No, but to amend, like
So
to do a
we're gonna
resolution.
request at some point for the legislature to allow for more time.
I see.
Which is.
For
probably-
mediation.
Yeah,
Okay.
which is probably a total.
So I'm gonna just give you a heads up, on one issue on mine, because I just exceeded the 1 year last month. But I was here last year, I had to go off island, my son-in-law had cancer, so I had to be there to assist. He sadly passed away, but then I was able to finally come back to, get on top of it. But the one big hurdle was when I came back to request for a survey. I have a history, again, a story on my surveyor. An initial one was done in 2008 or 9. The final map was never submitted. The surveyor that did that, the owner of the company, passed away, and I wasn't aware of it. I thought I was given a lease, thinking the map was submitted, but then 2022, I was following up. I was told the map was never received. So then they mentioned to me that Meliton Santos passed away, right? So I didn't know what I needed to do to get a new map again, because then that's what gave me a cloud also. I have a lease, but no map.
Right.
Anyways, come last year, I went to the same company I did in 2022. 2022, they gave me approval to go and survey, but as soon as the company reached out to Land Trust was providing documents needed. Land Trust put it back because, right, a few clouds, right? Back in 2022 was $3,200 to survey 1 acre. I'm not sure if you're aware. Last year I went to the same company and they're charging $12,000 for 1 acre. So that's a hurdle I just really can't get over to be in compliance. Other than the surveying, I haven't cleared, I haven't done 2/3, but I've reached out to PICA in 2022 and I realized I had clouds and all that. I'm like, this is where I'm at. And I wanted to bring a container. I wanted to bring backhoe, but she said, no, you read the lease and abide by the lease. So I can't put a shovel to the dirt, right? Until I have a permit, right?
Yeah.
And I can't get a permit to clear until I have the survey, right? And so there's no way I can kind of go backwards, right? I mean, like the previous issue here, right? What is it? The cart before the bull or whatever. And so everything prior to me sitting down, pretty much spells out, right? I see, and I'm thankful, that this time we're trying to fix things up. I've been patiently waiting and then to get hit with a $12,000 survey, like I have a lease already, but
So she has a lease? Oh.
So I was given a notice to remediate.
She has a lease, has been issued a notice to remediate last year, and
Yes.
like she mentioned, it exceeded the 360
So after I
days.
went and checked the surveyor, I came in and asked, I said, I have no choice but to come here and give you back my lot for you, Land Trust to survey. I know and I've heard that Land Trust has funding for surveying and infrastructure, right?
We've already identified tracks for that, but I
But
think
for
what we could
lessees,
do,
is that funding that's allowed for lessees? I know
Can
you
we-
have so many, but.
Can we just set up a meeting
Yes,
also?
no,
Let's
but my
do that.
initial thing was just in general, to plead with the board, to look into with the staff, right? And as you all would come to an agreement, to come up with a resolution to extend that notice to remediate period from 1 year
I
to 3
think
years.
that they're working
We're going
on
to
it.
the- yeah,
Yeah,
we have to
working on
You
it.
cannot do it in this
Interim.
board.
No,
You're
I'm not
obligated. You have to-
expecting that, I just wanted to come in and be heard as a lessee, right? That I really will support that, if that's already on a roll, right, within the office or
So
the
that's
board.
something that we have to go to the legislature.
Yes,
and
I
that's something that
understand
we've
all that.
identified.
So just to let you know, I'm reaching out to some senators already, so that way it's done the proper way too. Mind you, I just watched a public hearing the other day, and you were the only testifier. That was done before it went through the board, and so I'm like, well, I've been there last year to get help because of the survey and see what they, and I was never helped, so I questioned an employee there, because I'm not part of a business or commercial lease. I can't come to the senator to, help make a present, bill or put it through
No, I
hearing.
went there to testify on a
Yes.
bill.
Yes, I hear,
I'm just saying, wow, do I have to be a business to be heard, to go straight to them? I'm being
You
told to
ask
come
them.
through here.
You're being heard, ma'am.
Yeah.
So-
No, I
You
know,
ask them.
I know the proper way is to come through here, but I decided to go just straight there because I see, right, you have senators pushing bills through without coming through the board, right? No resolution.
They tried.
Yes, but that's my point. We need to straighten that
Because
up
what was
too,
my
you
last
know.
statement on my testimony? I said, if these two conditions cannot be met, I do not stand in support of the bill.
Okay, I felt bad, and too bad it went that route before, instead of coming through here, because I really feel, right, that
That's
you're
actually the
trying to
process,
straighten up, right?
So
What-
if I may,
Okay.
thank you for your
Okay.
public comment. We've been working with Ms. Iriarte,
Okay.
and she's been updating us on her issues and I don't blame her. She can't move forward with her farm or any activity without a survey. And that's, she don't wanna end up encroaching in somebody's yard, which is understood, and that's part of the NTR, which is survey. Like she mentioned, she hired and put a down payment to know about, the person that passed. She went in 2022, got a quote for $3,000.
Yeah.
2 years later, it's
They
now
put
$12,000.
The documents,
So she's gonna continue to work with you, right?
Yes, I've
Yes,
been
she's
trying.
been very good
Okay,
with
so
us.
As
Yeah.
long as that's agreed, then we can adjourn.
So my issue is just that my notice to remediate 1 year has.
We
lapsed.
cannot make a
So she's gonna,
Yeah.
yeah,
Yeah,
they're
no,
gonna, they're
but
gonna
I'm
work
just
with
letting you
you.
know why I'm here and hoping to, how do you say?
Submit
Yes.
a letter and we can
Schedule.
decide that in the next board meeting to give you the extension.
No,
to
but is
remediate.
that something you can do just within here then? It does
No.
not have to amend the law, because the law says 1 year.
Yeah, it's a law. So we have to go to the legislature,
Yes.
and that's something that,
So
we're
would I
working
have
on.
to come back and be included in the agenda for next,
I think
or I'll just
Let's
count on?
meet, let's
Okay.
meet, and then see what, we can come up with as strategy. There's more than
Yeah.
one, off the top of my head, there's more than one surveyor on
Yes,
that
but
list, so
Thankfully,
maybe
you brought,
to-
thankfully you brought that up, the listing from Land Trust, 3 of them last year, I think there's only like 6 on the listing. 3 of them don't accept Land Trust.
so there's still.
Okay.
Or,
We'll-
I don't,
We'll meet.
so I'm just so strapped, I just
Yeah.
don't. But if I'm thinking the notice to remediate, if you extend it, then who knows, maybe more surveyors will come in the next year. I could cough up 12,000 if you give me time, but even that's ridiculous.
But we're not
Yeah.
terminating anything
Yes, that's my
anyways,
concern,
so
that's why I came today.
We're not,
Yeah.
and we wouldn't do it without you being, notified in advance. So there's a process,
Okay.
and just be
Appreciate, I
reassured
just need
that.
to be assured of that, yeah.
But we'll
Because
schedule
I've
them.
waited, that long and,
Thank you so much for coming in.
okay, thank you.
Thank you.
So I'll just meet.
Now you can do it.
Yes, yes.
I make a motion to adjourn.
Motion has been made to
I'm
adjourn.
sorry.
Can I get a second?
Oh, one moment, yes?
Makepeace had to go.
Oh, so what does that mean? We can adjourn?
It's just the two of you.
Why,
I think-
why didn't you inform us before she left?
I'm sorry. She had to go
Yeah, no, so that we could have just adjourned and
back then.
That means we don't,
we can't, we have to leave the meeting open.
yeah.
Hold on.
Yeah. Are you laughing?
It'll be a recess. It'll be a
I
recess.
said, are you laughing?
No.
Yeah, it'll be,
it will
I
be
think
a
we have to
recess.
recess,
You can't, no problem.
unless you
One
can
second,
ask her
I
to
can
come
just-
back. Wait, he's gonna ask her to come back, just to adjourn.
You can recess and then the beginning of the September meeting, right at the beginning, you can adjourn.
Well, let's just try to see it.
Oh, yeah, her name's not up there.
Annie, can you log out real quick so that we can adjourn? Yeah, real quick, so we can adjourn. Okay, thank you.
Okay, thank you so much. Thank you, thank you.
Thank you, bye. Okay, she's gonna log on.
Great. you.
Bring her back in the room here.
Or she could just join and click.
That's not my area.
There we go.
Speaker, what is speaker on?
Annie, can you hear?
That's her husband.
Commissioner
I
Makepeace.
can hear you, can you hear me?
Yes.
Okay, a motion was made to adjourn. Can I get a second?
Yes, I second the motion to adjourn.
Okay, a motion is made and second. We go in for a vote. All those in favor, say aye.
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 Motion carries.
Thank
Have a
you.
good evening, everybody.
Thank you.
Thank you, staff, for staying behind. Our goal is really to try to get everything done like 3 o'clock.
Sir?
So, you know, because it's also a lot out of your day too.
5:35 PM.
And I kept these guys back, so I owe them.
I know,
Compliment.
I know.
For lunch.
Okay.
Next meeting.
Oh,
Next meeting.
September
17, 1 PM.
Okay.
The next meeting will be September 17 at 1 PM.
The time now,
Can I just leave my stuff here? I really need to use the bathroom.
Yes.